order's not here quite yet, but we're not going to start by taking a plea. Two, more fundamental and frustrating, a few defendants did not get brought over, not the sheriff's fault, internal fumble. And so I'm gonna let you know who that is, and you can let me know, should we scramble to get this person on a Zoom screen, or get this person brought over, or look, all we're doing is waiving arraignment today anyway. So Ms. Gordon, Mr. Few did not get brought over. We will work hard to get him on a screen or to get him brought over. I know you need to be in another courtroom in a little bit. Tell me how you'd like to manage that.
Appearance and waive arraignment, and then are not guilty pleas on properly both of the two cases.
Both his cases. Okay. If you need him to be in court, we'll add him to a special whenever. I know you can see him on your own at a schedule that works best for you. But what we'll do, if you will file, we've got the waiver forms there. So if before you leave for your next appointment, if you get the waivers in, he is in the case ending in 322 as well as the case ending in 438. I think they're both Hiles specials. So one lawyer, just different cases. And we'll get a scheduling order in place for both those. So let me do that, waive and schedule. So then I think the one other thing you have this morning is getting an update from Mr. Wright. I don't see him on the screen, but maybe it's under an alias.
We're working on it.
Okay.
I'm here, sir.
You got it?
He's
Yes,
Kendrick
sir.
Wrightwell.
I'm here.
Okay.
Is that Mr. Wright?
No.
No.
I'm
No.
here. Yeah. Sir, I'm here.
All right, but you, all right, we're good. You guys work on that. No one's late yet. I'm just ticking through the folks who didn't get brought over. Israel Bird did not get brought over, but I don't know that we have a lawyer for Mr. Bird yet. Melanie Steffo is listed, but she typically doesn't carry over to indicted cases. So I don't know if you, Mr. Hiles, have a roster. And Mr. Bird is one of these twofers. He is on both your cases.
Yes. It was my understanding that he would receive limited copy of the assigned report.
That's Ms. Cabrera, and I don't think she has someone in either of the cases yet. So it could be Ms. Cabrera. She is next door for the foreseeable weeks. So maybe we can work with her. She is doing email. So we'll see. But that means we don't need to get Mr. Bird here because he either has no lawyer or he's yet, or his lawyer is in trial next door. So we'll work through that. And then Mr. Marriott, who is Mr. Apt's client.
No, David, I'll bring all my applicants.
Okay.
We would like, I mean,
So we have two options. We will either physically get him here because we've got a channel to the sheriff saying, hey, our bad, but could you bring someone over? And they will. Or we could see if it's quicker to get him on Zoom. Mr. Apt did file a bond motion that's on the calendar to be discussed. So we can do that. You need to tell me your preference, having Mr. Marriott here or on Zoom or first available. I don't know.
is it this afternoon or?
Let me check with Deputy Gordon. We'll see what he says about that. And I think that's it for folks who didn't make it.
I have a conflict this afternoon, that's why.
Right, you'd prefer AM. You prefer in person. If we could pull off AM in person, then that's best. Okay. Hey, Deputy Gordon, are you able to get an ETA? It's that Mr. Marriott, his lawyer would like him here rather than on Zoom. If it could happen this morning, if the answer is it wouldn't be till the afternoon, then we should try to get Mr. Marriott in a Zoom booth and do the bond hearing that way. All right? So we'll circle back to that. There's Mr. Wright. Good morning, Mr. Wright. Can you unmute?
Yes, sir. Good morning.
Good morning. How you doing?
I'm doing great. You?
I'm doing well, probably not great, but I'm glad to hear you're great. Where are you right now?
I was doing some yard work with my grandma's boyfriend and my big brother.
Okay. Is that where you're supposed to be right now?
Yes, sir.
All right. How's the summer been going?
Man, it been going regular for me. Like, it's not nothing new.
Okay. And how goes all the programming you're supposed to be doing?
How you said how is all the programming I'm supposed to be doing?
Yeah.
I mean, good. We haven't started the summer camp yet, but I'll be starting the summer camp tomorrow
Where will that be?
at Permanent Center on Kempton. My teacher, Mr. Parham, said he'll allow me to join the one on Kempton because it's less I guess less people over there because he don't want me getting to nothing. So he said he'll like me with less people is there.
Okay.
So I'm gonna go to the one on Kempton.
Got it. Ms. Gordon, do you have any updates on behalf of Mr. Wright?
Your Honor, I'm gonna let Ms. Eagleton do most of the talking, but my understanding is that Cameron's doing really well. He's doing what he's supposed to be doing, staying out of trouble and doing great. But I'll let Ms. Singleton give you details.
Okay. Good morning, Ms. Singleton.
Good morning.
What are the deets on Mr. Wright?
Well, he's still participating with the GED program. They are on a 2-3 week break. They don't take a summer off, so they are on a break right now, but they will be starting classes back up. I had a meeting with everyone involved with him on last week. The therapist said that he's doing really well with the therapy. He's participating in anger management. They had a conflict resolution portion that he spoke up and was a class leader in, and they feel that he's really motivated to make some changes to assist with his life. He's been doing the community service there. The gentleman that's working with him there, they realized that Cameron has a business mind, and so they started a little car washing situation with him over there. So they're getting his supplies together. He seems really eager and excited about doing that. So they've got him doing some car washing as well as some unloading and loading on the docks and things like that. So he is getting some community service. He had a little difficulty on the pre-test for the GED, but we are set, it was because of distractions. So we're setting up a specific.
Does he do that from home? Is that where or is he at the At Promise when he's?
He's at the Promise Center, and so the people walking past the door catch his attention. He had his phone with him. So we have set a specific date, came up with a plan, where he's gonna take it again on a specific date. We're not gonna allow him to have the phone. He's gonna be in a room they're gonna set up specifically so he can't see people walking around. Just make some provisions to make sure that he can be successful, because he's shown that he's academically strong in a couple of the classes, and so they feel like that he could do much better.
Okay.
So we're gonna do that on July 21st, I believe. And I had to talk with him about that this morning, and they're also gonna refer him for some additional testing, psychological examination, to see if there's anything else they can assist him with, possibly some medication for ADHD and things of that nature. But everything will still be at the Promise Center. They're really excited about him. They describe Cameron as being funny, interested in learning. They showed me some videos actually of a lot of stuff happening in the classroom and him focused on the board, trying to do the work.
Yeah.
So they said a lot of really good things about him. The Covenant House is part of the program, and so if Cameron is still there, he'll be 17 in December. If he's still there at 18, working on whatever he's working on, they're going to assist him with housing.
Okay.
So at 18, they can help him find his own place.
Excellent.
So everything is good.
Mr. Wright was saying something about shifting to a different at Promise Center because there were fewer people there. Does that ring a bell with you?
The, in Promise Center, you go to 2 locations.
Mm.
So he would go, they want him to go to a specific location for summer camp because of a smaller population of kids at that. But he still will go back and forth between the 2 classes.
Okay.
Yeah.
Got it.
So it's just, they think that he would do a little better at the environment at one location than the other.
Okay, got it. Mr. Wright, did you follow all that? That was a big update from Ms. Singleton. Do you agree with all that?
Yes, sir.
Okay, anything you want to add?
No, sir.
When are you sitting for the pretest, the GED pretest again?
I'm not really sure. I'm not sure.
Okay, sounds like it'll be the 21st, so that's a few weeks away. All right, and you said you're staying with your grandma right now?
Yes, sir. My grandma and my dad.
Got it. Okay, well, excellent. You have any questions for me?
No, sir.
How are you getting to these places you need to go to? How do you get to the At Promise Center?
My grandma, she take me early in the morning, and then I just catch the bus back home.
Okay. Well, good. Ms. Singleton, when should we all chat again?
Well, I think late September, early October.
All right. Ms. Gordon, I don't remember how we got word to everyone. Do we get word to you and you get word to Mr. Wright, or what's the best way to do that?
I will.
Okay. Mr. Wright, I'm gonna wish you the best for the rest of your summer with summer camp and everything else you're doing. And we'll have a conversation in either late September or early October just to see how the summer wrapped up and how fall is going for you, okay?
Yes, sir.
Any questions?
No, sir.
All right, good luck with everything. Be safe.
Okay.
So Ms. Gordon, once you do the waivers, you can get them to Deputy Gordon and be on to your next calendar.
Thank you, Your Honor.
Sure.
Have a good day.
You too. Thanks, Ms. Singleton.
Welcome.
All right, so if we press on through the calendar, Michael Nail shouldn't be here. His lawyer waived. Ms. Davis, Mr. LaScala filed a waiver, so we'll do a scheduling order. Ms. Nelson excused their appearance.
Judge, that would be my case.
Oh, that's yours? Okay. Ms. Dilligard, Ms. Nelson got the waiver from LaScala, and we'll do a scheduling order, and unless there's something you need to tell me about the case, that's what we got. Dilligard. We talked about Mr. Few. Mr. Howes, how is discovery going to work in these 2 cases? Is it just an evidence.com? Is it back your truck up to the DA's office and we load servers on it?
For the most part, it'll be a Dropbox. Outside of the phone extractions, those are too large. So I'll have to coordinate with the attorneys to get a large external.
Okay. The connection between the 2 cases is defendants. Are these going to be joined in the end, or they're very discrete, separate, other than that we've got the same defendants?
Which I'm going to join them.
You're going to join them.
For full candor, there was, as we were getting shell casings tested, more were uploaded to NIBIN. And then it connected to this time frame of December through mid-January of multiple aggravated assaults by many of the same individuals. And
so there may be a new indictment that combines these 2, but has other incidents as well.
yes, Your Honor, it's a very, very real possibility.
Does it add more defendants?
It could add 2.
Okay. Well, I look forward to that. For now, Ms. Gordon has waived arraignment and we're gonna move forward. Does it make sense to put together a scheduling order, or what's the forecast for when the mega indictment, not that these were small to begin with, the super mega indictment comes out?
We can go with the scheduling order, and if we need to alter it, we can alter it.
Okay.
I'm gonna be out for 2 weeks, starting Monday.
That's good for you, but the scheduling order is a scheduling
Well,
order.
it's not gonna, it's already, I'm ready to serve discovery.
Okay.
Like, it's not gonna, I'm just saying as far as the timing for the re-indictment.
Oh, okay, there won't be a whole lot of work done on that while you're out of town.
Not by me, but I've assigned a lot of tasks out,
Okay, to your staff?
that and with APD.
Okay. All right.
So,
So there'll be sort of one that binds them all.
yes,
Okay.
I think it will ultimately be cleaner.
All right. Unique Jones, I think is not represented by Mr. Kraft. It's Ms. Williamson.
So, Judge, we got an issue there too, where she's gonna end up needing another attorney because
Unique is a female?
yes,
Okay.
female. Her Mr. Kraft entered appearances on Unique Jones and J.D. Chambliss. And then Latanya Williams entered appearances on his as soon as he left for both of those, but they will be.
He left as in Mr. Kraft doesn't do the kind of thing he used to represent.
Mr. Kraft went to the newly formed Western Judicial Circuit to the DA's office.
Okay,
So he's no longer
wearing a completely different hat now,
Yes.
neither here nor a defense attorney.
And then Ms. Williams turned around and just filed entries on his cases.
Okay,
And I
she
don't think-
absorbed his caseload.
And I don't think that he'd made the connection
Okay.
of the conflict there.
And so you think that whether it's Kraft or Williams, because there was an entry filed in both, they have to drop both as opposed to just drop one?
I'm not saying they have to drop both, but there's definitely a conflict there, and I don't know if there's anything been done. I wouldn't think.
I mean, they don't have I guess there could have been client communication. So it's Unique Jones and Jalen Chambliss. Okay. Williams. So we'll need to, I guess I'll send an email to her copying you saying these are co-defendants effectively. Unique Jones is not in the 438, but she'll be in the overall, so they'll be co-defendants. Or is Unique Jones in both cases?
He's only in one.
Okay. All right. So Ms. Williams may be able to keep one of the two, but not both.
Yes, that's possible.
We'll have to get her input. All right. All right. Number 8. Deputy Gordon, what did we learn about getting Mr. Marriott on a screen versus in person?
He's being transported. We're waiting for transport to confirm that. I talked with him.
Okay, but it would be before noon?
Apparently, yes.
Okay. So in person it'll be. Appreciate your patience. If you want to go circulate for a while, it won't be in the next 30 minutes. All right. Sorry about that. All right. So Israel Bird is in both cases. And we think that may be Miss Cabrera. I don't remember who said that. Maybe it was Miss Singleton somehow knew that it'd be the conflict defender. So we'll check with Miss Cabrera on that. But he's not here. Mr. Few has Ms. Gordon waived scheduling order. So Chambliss, I don't have that he's not produced. So Chambliss is here?
It was
No, we
canceled.
canceled him because the attorney's on leave and she filed a waiver.
Okay. All right. So he's not here either. How about Omal Maloney?
He's on board.
He's on his way? Okay. And Mr. Regis is on the case as far as anyone knows?
Yes, sir.
Okay. I guess we should reach out to Mr. Regis. All right. So Mr. Maloney is a juvenile. Got it. And same with Nicholas Shannon. Okay. And does Ms. Warlick represent Mr. Shannon?
I do, Your Honor.
Hey. Hi there.
How are you?
Well, I'm happy that you're involved. Getting lawyers for this many defendants gets to be complicated. So Mr. Shannon is on his way here. The juvenile transport system often runs at a different time frame than the adult transport system. So once he's here, we can get him in court so he can see you and you can see him.
Okay, Your Honor. I did submit a waiver. I wasn't aware that the court had a particular form. But if I can get that form, I can fill that out and get.
Nope. As long as you waived arraignment, the magic in mine is that it also includes a box that you can check saying, I do opt into discovery. Most people do, but that way it's a 2-for-1. You're waiving, you opt in discovery, and that triggers the state's obligation to hand everything over. And that scheduling order sets a deadline for the state to do just that. I know you filed a motion to quash the indictment, and we'll get to that at the appropriate time. But you also will have a separate motions deadline that is well after your receipt of all the discovery. Were you planning on opting into discovery?
I was, Your Honor. And I would also just like to get placed on the calendar for a bond hearing. I don't know how tricky that's going to be with the subsequent indictment, if he has to bond on the new charges, or if he's even going to be if he's even going to have new charges. So,
Right. Well, part of that is not Mr. Shannon's problem. He has a current set of charges and he's entitled to be considered for bond in connection with those charges. But to your point, it could be that I hear everything and say, great, I set a bond of X. And then 2 weeks later, there are more charges and he would have no bond for those additional charges. And so it may make sense to avoid a sort of yo-yo experience for him where I don't know if he could post bond or if I'd give him bond, but if I set a bond and he posted it, he within a matter of weeks could be in a no bond situation again. And that can be a little disruptive. But the flip side is the state's going to reindict when the state reindicts, and he could be in holding until then. And what if there are no new charges against him in the new indictment? We would have missed out on getting a bond hearing earlier. So I'll defer to you and you can explain to him the fact that he may get a bond round one, but round two could get more complicated for him. And we'll just see where that flows.
Your Honor. I understand that some members of the state have leave. I'm just trying to figure out who I need to talk to about possibly negotiating.
I'll reach out to you today.
Perfect.
Is the contact info on your entry?
Yes.
Okay,
And then I can email you my cell phone number too.
that'd be great. Thank you.
All right, so that's the guy with the mustache is who you're going to be dealing with. That's Mr. Hiles, although you may have heard what he said. He's out for 2 weeks. So starting tomorrow, you said? Starting next Monday.
Monday at the latest, could anytime.
Okay.
Oh, okay.
Congratulations with all that. But I would strike while the iron is hot and try to connect with him. And then he'll be out of pocket for a little bit and then he'll be back. Are you comfortable forecasting for Ms. Warlick if Mr. Shannon's outlook is not favorable with the whatever the new charges would be?
I don't know. I've got,
So many moving parts.
yes.
Okay.
Lots of information to review.
Okay, got it. Ms. Warlick, you've done a waiver. Mr. Shannon will be here you're on leave, so I don't want to impinge on your break too much. Do you want to sit tight so you can at least say hey to Mr. Shannon when he arrives here?
I would like to, Your Honor.
Good. Okay. Then you can slide back into being on mute. And once I learn that Mr. Shannon's here, we'll bring him out and I'll explain a little bit about what's going on. You can do the same and we'll chart a course forward.
Thank you, Your Honor.
All right. Thank you.
Your Honor, it looks like Mr. Regis filed an entry and a waiver yesterday.
Oh, that's like him to not tell us. Okay. All right. Well, when Mr. Maloney gets here, we'll bring him out and I'll explain what happened. So waiver and schedule. Thank you for checking that. Same. And then Mr. Marriott is on his way. Mr. Howell, did Mr. App do a waiver of arraignment or we'll just do that when he's here as part of the interaction?
We'll handle that.
Okay. And we've got Jerome Clark. And Mr. Hoover did a waiver and I've got your list. But we didn't excuse, or did you excuse that?
Mr. Hoover's in trial
Yes, I saw him.
Okay.
with Lethbridge. He's been in that.
Okay, he's with Cabrera in the Coolio? What did we call it?
Cash out.
Cash out. Sorry. Yeah, cash out.
3 decades later.
My kids would be going like, oh my God, Dad, did you really? And then they would change their last name. All right, cash out. Starts with the same letter. All right, so he did a waiver. Is Jerome Clark here? We didn't produce Jerome Clark?
No, he would be on that Pleasant Transport.
Okay. And then the final co-defendant is Cameron Miles Pratt. We dealt with bond, there was a waiver, and so that one is doing whatever it's doing. Okay. So if I go back through this calendar, we took care of Mr. Wright, Nail, Unique Jones. We got to talk with Ms. Williams, got to talk with Ms. Cabrera about Bird. Fuse taken care of. Shambliss is the other one with Williams, Maloney, Shannon. Okay. So when Mr. Marriott gets here, we'll do his bond hearing. That gets us to our inquiry calendar. We have Ms. Jones. Is Ms. Jones here?
And I guess the state moves for bench warrant.
That's a surprise. Okay. Ms. Jones, are you online? Nope. All right. Well, Mr. Wooten, I appreciate you being here. In case she walks in, one of your colleagues knows how to reach you?
Yes.
Okay. Is a 9 o'clock calendar. Mr. Barber withdrew.
So you saw the motion. I don't know if the time period, I don't know if you signed the board.
I think I said everyone needs to come to court. Given the nature of this case and what people, I want everyone in the same room saying, no, I'm not going to be the lawyer. And yes, I understand that. I don't trust that. I don't want it just on paper. I want to. So I don't remember how I left it with Ms. Nelson in terms of the date, but I said, we need to put this on a calendar and have a hearing about the motion to withdraw.
And there is, Judge, I think, a court date on the 25th related to the bond, transferring the bond from one indictment to
Okay.
another. And so I assume we can just.
We take it up then. And then that would be Ms. Brown. I guess she'd need to talk, because Mr. Barber was retained. And so she'd need to talk about what she's going to do to get a different lawyer.
Right.
Okay. All right. That's it. Thanks.
Thank you, Judge.
You bet. And then we've got Kendrick Brightwell. He was the other guy on trying to be Mr. Right. Hey, Mr. Brightwell. Mr. Brightwell, you there?
Yes, sir. Yes, sir.
All right. Whoops, that's the wrong person.
Yes, sir.
I hear you.
I'm
There
sorry.
you are. Okay. Mr. Brightwell, you were in court about a month ago,
Yes,
and
sir.
you were going to hire an attorney. It is time for you.
No.
Your Honor, I think we got a mix up there. We had another client on the calendar. I think it was Darrell Jackson. That's the one who was supposed to be hiring because he didn't qualify. Mr. Brightfield did qualify, and he filled out a change of address and everything. So I think it was just a misunderstanding. It might have been also because I forgot to file a waiver, but I have filed that since yesterday.
Okay, I'm pulling the case up. So Mr. Brightwell has no co-defendant, so we'll talk about whatever name you mentioned in just a sec. So you, Ms. Rios, will be representing Mr. Brightwell.
Yes, Your Honor.
Okay, there was a change of address filed about a month ago, and it lists an address of Martin Luther King. Is that where you live, Mr. Brightwell?
Yes, sir.
1981?
Yes, sir.
No apartment number?
Oh, it's two. Two. I'm sorry.
Apartment 2?
Yes, sir.
Okay, that's not on there.
I updated. I try. I'm sorry. I'm sorry.
No, you don't have to. It's not on the change of address, but we'll add it. So apartment 2?
Yes.
Apartment number 2, and Rios represents Mr. Brightwell. I don't understand how we got our wires crossed, but it's been that kind of day apparently. So you have a lawyer, you're good to go. Ms. Rios, you said you filed, it's not in the docket yet, but you filed a waiver?
Yes, Your Honor.
Okay, so Mr. Brightwell, your lawyer is going to get discovery from the prosecutor and then reach out to you about where we're going next with the case, okay?
Yes, sir.
You have any questions?
Yes, sir. Well, yes, sir. I do got questions. I got a lot of concern, but I ain't want to out talk. Can I speak, please?
I think
So
your
it's-
concerns are questions for me, not the judge.
I'm sorry.
That's okay. So Ms. Rios will give, do you have his phone number, Ms. Rios?
Yes, Your Honor.
Okay, Ms. Rios will reach out to you and you can share your questions and concerns with her. She may say, hey, I need to get discovery first, but you guys can talk. And I'll see you next for something other than, do you have a lawyer? You got a lawyer, you are good to go for now, okay?
Okay.
All right, I appreciate, sorry for the confusion. That's on our side, not yours. I appreciate you dialing in.
Yes, sir. Have a good day, y'all.
You too, bye-bye. All right. That's all I got for this morning. Sort of a flat calendar. Is anyone already here for the final plea? We could do that, but that'd be real early.
No, and I'm at home, but I've also come to the court for the 1 o'clock calendar.
Okay, well, we will see you at 1 o'clock, along with lots of other defendants. Mr. Howell, I will come back out as soon as we know that Mr. Marriott is here. And we'll handle the bond hearing then. We'll also bring out, I think it's Mr. Maloney, if he's being, I think there were a couple juveniles who were being brought over, just to let them know what's going on. That's it.
I would like to speak with Mr. Marriott just 5 minutes.
Sure.
I'm going to give my phone number to the deputy. He can just get that.
Okay, sounds good. Appreciate your patience. Anything else from the state?
No, I'll be here I'm gonna hang around, we got the family here.
Okay. I appreciate that they're here. We'll do the bond hearing, and take it from there.
All right.
Oh, Ms. Rios? Oh, she already dropped off. Oh. Good morning. How are you?
Hi, that's okay. I'll say it when it's finished.
Okay.
It's like eight right here. Eight co-defendant.
Yeah, I think so. It's two different indictments, two different murders. There's one with 3 and then the other one has 8, but those 3 are also part of the 8.
Okay. Awesome. If we're not, how about that?
That'll work.
To me, the day is, I got all day.
No, I understand how that works.
I'll send it to you tonight.
Ms. Warlick, I think Mr. Shannon's here. Okay, great. So we're gonna bring Mr. Shannon out first so you can get off this call and onto whatever else you need to be doing.
Okay, thank you, Your Honor.
You bet. So if you could bring Mr. Shannon to the podium, please. Thank you.
Right here.
Hey, Nick.
Hey, how you doing?
I'm all right. So we waived arraignment. We're gonna take up bond at another time.
Mm.
I am gonna be speaking with the prosecutor to see if we can work something out.
All right.
They're anticipating bringing another indictment. I don't know if that'll increase your charges or not. But if they do add more charges, we may have to come back and address bond on the new charges. But right now, arraignment's waived. I'm opting in for discovery, and then I'll just be speaking with the prosecutor. If you have questions for me, just hold them because we're out in the public, and I'll come by and see you. Okay.
Yeah, ma'am.
Hey, Mr. Shannon, I want to introduce myself. I'm Judge McBurney.
Hey, how you doing?
I'm doing all right. How are you doing?
Good.
Good. Your case has been assigned to me. I met Ms. Warlick earlier this morning while we were waiting on you to be brought over here. She's waived arraignment, which just means she's in a plea of not guilty for you. That means she will soon be getting the discovery in the case. So that's things like police reports, or if there's surveillance video, or if they found shell casings, it'd be, what did they find? All that kind of stuff. And Ms. Warlick's going to read over all that. She'll talk to you about what's in there and talk to you about whether there are motions she wants to file. One of those things will be bond. So we will have a conversation about bonds, not today, but sometime soon. But the part she mentioned that I want to repeat is that the prosecutor, he's the gentleman seated to your right back there, he shared with me that there'll probably be a new indictment that will combine two indictments. Right now, there's another indictment involving a different shooting. Those are going to come together, and there may be a few other shootings that get mixed in there. If the state believes that you were involved in any of those other things, then you will have new charges. And we have to figure out bond on that as well.
Yes, sir.
So Ms. Warlick is going to be talking to the prosecutor to get a sense, hey, is Mr. Shannon going to have some new charges? And if the answer is probably so, then she may wait until we see what the whole picture is, because we really need to talk about bond, about the whole picture. Okay? So if it takes a little while, it's not because Ms. Warlick forgot about you, it's that she's waiting on the state to sort out what that new indictment is going to look like. Either way, you'll be back here. We'll have a conversation about bond. I'll hear from her. And if there's anyone from your family who wants to be heard on your behalf, I'll hear from them. I'll hear from the prosecutor. And then there are family members of the victim, and I will hear from them as well. And then I'll let you know what I'm going to do about bond in your case. But in the meantime, the prosecutor's getting this discovery to your lawyer. She'll be looking at that, and she'll be talking to you. Okay? Any questions about process? Not about the facts of your case, but just about process.
I really ain't got no question right now.
Okay. How old are you?
16.
All right. Well, it's nice meeting you, Mr. Shannon. You'll be back here when we do have a discussion about bond, okay?
Yes, sir.
All right. Ms. Warlick, anything else before we take Mr. Shannon back?
No, Your Honor. Thank you for letting me speak with him.
You bet. Appreciate it. Mr. Maloney should be the only other one here. Okay.
One other thing, I just wanted to confirm with Mr. Howells that he got my email.
I just saw it.
All right, perfect. Thank you.
You're welcome.
She's filed a bunch of motions. You don't need to respond to them yet. We just will need to tee some of them up, but I'll let you know if there's anything I want a written response from.
Please, yeah.
Yes.
Hey, are you Mr. Maloney?
Yes, sir.
Good morning, Mr. Maloney. I'm Judge McBurney.
Good morning.
Your lawyer is Mr. Regis. Have you met Mr. Regis yet?
Yes, sir.
Excellent. He has a conflict today and couldn't be here, but he's filed some paperwork on your behalf that is basically a not guilty plea, and that's going to move the case forward. It's waiving arraignment, and he has asked the state to give him all the discovery in the case, which would be police reports or witness statements, things like that. Mr. Regis will review those things. He'll meet with you, and we'll figure out what's happening next with your case, all right?
Yes, sir.
I just wanted to meet you, let you meet me, so I'll be the judge handling this case wherever it ends up going, and it may have some twists and turns in it. Mr. Regis will be your lawyer throughout it, so he'll be at your side. If we're ever going to do something substantive in your case, making decisions or anything like that, Mr. Regis will be here, and he'll be advocating for you, all right?
Yes, sir.
Any questions about anything?
Any farther court dates?
So your next court date would likely be if Mr. Regis files a bond motion. He's going to talk to you about that. There are a whole bunch of charges in your case. I don't know which ones you're in. There's also a possibility that the state brings more charges that would involve you. And so Mr. Regis may wait to see what does the big picture look like before he says, let's come in and talk about bond. But that's probably the next time I'd see you would be a discussion about whether you should stay where you are at the YDC, or if I should set a bond that if your family can make the bond would mean that you would be at home waiting while we work through the case. But Mr. Regis will talk either with your family or with you about that, and that's probably when I'll see you next.
Okay.
All right? Take care.
You too.
All right, I think that's it, other than Mr. Marriott is working his way this way. So you guys are welcome to sit tight, be outside, and we'll let you know when Mr. Marriott gets it.
Thank you.
Have a good day.
So, just want to speak with Mary.
See if they please and come in.
Mm-hmm.
Having two with them.
Maybe.
Are you done? Because my question is, you don't know why we like a two separate cases. Because of other people.
I'll leave that for you.
I'll ask the judges out. It's like, it doesn't.
I just do what she says.
No, that's not true.
See, I just listened to both of y'all, so.
I just.
1 second.
It's just gonna be like, how many, is it 8 people total
Right now.
right now?
Right now,
So
could go up to 10.
Okay, so right now we have a separate one that has 3 and then the other has 6.
Yes.
Okay.
And then 2 are duplicates. 2, they're not duplicates, they're on both.
Right.
Yep.
I said we wait to do scheduling order. It's just, how soon do you think you're gonna indict?
If there's going to be additional discovery, I think it makes sense to wait because we'll just be moving the discovery deadline and people might start filing motions because they're see their motions deadline coming on a scheduling order we did now. Then we'd just be moving those goalposts again when the new indictment comes in.
The other, if he adds 2 new
Yep.
people, then you
Yeah.
have to make sure they're lawyered up and.
So I think I agree. And then we just need to, one, leave you alone for a few weeks, but after you're back, start nudging you like, look, are you going to be doing this or not? And what's the time frame look like? I just don't want it to, I mean, we can always have bond hearings. We don't need a scheduling order for they just, we'll file them and we'll work through those. But since we're dealing with some juveniles, I want it
to
move expeditiously.
And, you know, for as many bad dealings as I have with APD, they've moved expeditiously
Good.
in this case.
Okay.
The latest incident,
It probably helps because this is also current. I mean, as you're not asking them for stuff from
you
23.
know, we're working through it together, so it helps.
Yeah.
So, I mean, I don't think anyone's even hit 90 days yet, but they made sure that they did what they needed to do before.
So the other 2 that you had are the juveniles or, yeah. Don't say one of each.
Well, I'm trying to think of now. I can't remember the birth dates. I don't think, maybe at the time, but I don't think.
Now.
Yeah.
Okay. Okay.
Is this Mr. Van Arsdale's family?
Yes.
Okay.
And Miss Julia did do her history.
Yeah, so she's got Mr. Few.
No, she is.
Oh, Bird, right. Ms. Gordon has Mr. Few. Yep.
We were not mistaken on that person. He represented himself or the one.
Oh,
that he's,
Ms. Rios.
I went back and looked. I told her that yesterday. I said, my notes say this.
Okay, it's fixed. She's got the case. It's all good. I didn't think so, but
I didn't think so, but you remember that day, there was like 3 or 4 that she was supposed to be not.
Yeah.
Miss Wood left her.
yeah.
All bars.
I'm surprised Miss Jones didn't show up. Ms. Simpson, you had a question.
I did, not related to this calendar.
Okay, well, we're holding for Mr. Marriott now.
There was a plea that we did, Mr. I pronounce his first name, last name is Danny.
Yes, this is the one that your office doesn't like because it's probation followed by jail.
That floated sentence.
Yeah, which Judge LaGrua used to do all the time and somehow it worked out. So you have to find some old timers and see what did they do for Judge LaGrua.
Yeah, so they're asking, if you would prefer to have to suspend that count, suspend count 3. So that way our admin staff can process it, because he tried to report and couldn't because the field office couldn't find him because our admin staff couldn't process his sentence.
I think it's the way their sentence, I remember the way their system works, they can't put it in the system.
Because it looks like out of custody time and just custody time consecutive to out of custody time.
So I
Right.
think they have to rig their system to put it in.
Right, so, the clerk's office has accepted the sentence. That's the gate I worry about, and I got through that gate. We need to figure out a way for your system to be able to accept the sentence. I'd prefer not to turn that into a suspended sentence. I prefer to leave it as is so that it's a pretty serious hammer hanging over his head.
No, I completely understand it.
Yeah. What was interesting, because again, the Judge LaGrua did those. She was infamous for those. It wrapped people around the axle originally in the clerk's office and with the Department of Corrections, but they ended up understanding that it's a legal sentence. So they needed to figure out how to get it into the system where it's probation and then jail. But if probation went well, then she modified the sentence and the jail went away. And they resurrected that for his case.
So I wonder if they would have the same thing. I don't even know if this is, I don't know how they process it, so I don't know if they can like make it symbolize like a county time, right time being.
Yeah, I don't know. But it seems perverse to say you can't do this sentence that's a legal sentence because DCS's system can't figure out how to handle it. So I'm happy to engage with other folks if that would help. But I really want him to be under supervision. And man, we're over a month now that he's just sort of sitting there. And I'm sure he don't mind.
Yeah, well, I mean,
But it defeats the purpose.
Can't fault him because he didn't.
Right. So how do we move it forward?
I will need to get with Chief Carlton,
Okay.
and ask her to get with the, whoever the supervisor is over the admins.
Yeah, she's a good one to talk to for a couple of reasons. One, she's in charge, but two, she's been around long enough. She will have dealt with LaGrua sentences. And so she'll probably go like, here we go. And you can reassure her, I'm not a big fan of them. It's sort of fit for this case.
Yeah.
Because this kid seems to have really turned a corner, but he did something stupid. And so if we're all mistaken about having turned the corner, then we're done. But I don't foresee doing something like that very often. So please do get with Chief Carlton. And then if she says, no way, Jose, then she and I can chat and we'll see what we need to do. But I would love to get him under supervision. Thank you.
And my apologies for that travel permit that belonged to Judge Williams.
Pardon me?
My apologies for that travel permit I submitted.
Oh, yeah. It was because
Well, see, the funny thing about that is, so my Chief Sauer called me and she got a call from Chief Carlton. asking me to have that submitted. So I went through very, very many rings because I couldn't get the officer to submit the form correctly. Because the guy is trying to go on a cruise.
Yeah.
And
It's actually a gal. The defendant who is being supervised is a female. It's okay.
I was looking at the picture.
I know. Well, I'm assuming it's a female. It was, the name's like Nicole or something.
Yeah, it's a female name, but that is me.
Okay.
Police.
I don't know the case because it was.
But, when after going through many groups to get them finally submitted the right document,
Mhm.
just not yesterday. I went ahead and sent it to Ms. Nelson because I saw the departure date and.
It's soon. It's Friday or something.
Yeah,
Yeah.
it's on the 11th.
Yeah.
So I was like, hey, please ask days like this because they're trying to leave and the guy's gonna fall in and start charging. So I was like, he's gonna wanna look at that, so.
Mr. Howell, I want to forward you the Zoom link. What address should I use?
David at howelllegal.com, HOWELLLEGAL.com. So David at howelllegal.com.
All right.
Thank you for facilitating this.
Well, we shouldn't have to, but it's trying to get you the regularly scheduled event. Meaning we shouldn't need to go to all these lengths normally. All right, you're in.
One more person.
Yep.
One more. Isn't that fun?
Lists this address as Florida.
He had moved out of the jurisdiction.
Oh, really? Wow, that is way south in Florida.
Sounds like he can get on a quick boat to Cuba.
He's far closer to Cuba than Atlanta. Because the keys are right there. There's Cutler Bay, then Princeton, then Homestead, then you're on the Keys.
Wow. Wait.
I mean, I don't know these places. I just, it's what's on the map.
Beautiful.
It does sound beautiful. We should hold court down there.
Before my wife had her last baby, we got a convertible and drove from Miami down to the Keys, and that was a lot of fun.
I bet.
I want to do that on the Pacific Coast Highway.
Yeah.
Instead of that, we go to Disney twice a year.
All right, this needs to happen in about the next 5 minutes or we got to reset. Damari. Yeah, Marriott. Ms. Nelson says they have 4 folks pulling them now, but.
Yeah, we can call the floor and see if they can get it.
Okay. Marriott, like the hotel.
In reviewing the file, I did see where Attorney Abt did file a waiver.
Yep.
Yes. Correct. Mm-hmm. We have to, a Zoom hearing for judgment verdict. Correct. Okay, thank you.
you give me the number for? The power? Okay.
If he does show up, you got like 2 minutes to talk to him. Because if we're gonna do the bond hearing, I need to get started. I'm not trying to rush you. I just, that we've got a small window.
It might be best to reset.
Okay. Let's see if he shows up in the next few minutes.
Sometimes these things don't work out. And
It's just frustrating when we're this close. He's not far from that door.
Hello? I'm on speaker. And this is Lieutenant Eric Forrest. I'm actually trying to pull out, a resident on the north side. I don't believe if you know, right now. You want to pull out over the side? That's for the south side. No, I called the door, no one's picking it up, so I was gonna see if it's somebody on the door on your side to go open. Yeah, I did. Can you have them come out to alert you on that one? Are they in the office? Okay. Okay, thank you. There's somebody else.
Yeah, I'm Irish. And then. I think we're previous. Without.
Who's the officer on the floor? Johnson. Okay, we just need a person to pull it out and take it to the Zoom booth, that's it. You spoke with that individual on the phone?
Good morning, Judge.
Good morning.
Hey, so we have an officer going back up there. Apparently, he was supposed to be put in. I don't know if he walked out, but they're going to recheck right now, sir.
Okay, and I want to make sure I've got the right booth on the screen. I've got 5 North, booth 1.
Correct, sir.
Okay, we'll leave it open. If we can make it happen in a couple minutes, super. Otherwise, we'll just get them over here on another day.
I'm clear, sir.
Thank you.
We're just gonna grab a sip of water, guys.
I guess that's a problem if the door doesn't open. I assume it just pulled on open. Can you try to go to 2? I'll try loading up 2. It's ironic they're able to pick the locks when there's a lock on a cell, but when there's nothing, they can't get the door open. You guys
Hey,
know,
Judge, see if you can do 5 if they can't open that, because we have defendants already in 2, 3, and 4, if I'm not mistaken.
all right, I'll do 5.
Okay.
Ms. Nelson, you should be buying everyone donuts.
I've made worse mistakes, Ms. Nelson. Do you still need to talk to him?
Maybe a sign we just.
All right, I got 5 on the screen now. If he can go into 5.
I'm clear, Judge.
That one actually has a doorknob.
Is it unlocked?
Yeah, exactly. Doesn't look lockable from the inside.
Anything's possible at Rice Street.
Permanently locked.
Hey, Judge, we getting them switched right now. Okay, fine.
Thank you. Hey, are you Mr. Marriott?
Yes, sir.
Glad we finally connected. I'm Judge McBurney, and I'm going to have you speak with one of your lawyers, Mr. Howell, for a few minutes. And if we have time, we're going to do a bond hearing today on your case. If we don't have time, at least you will have met with one of your lawyers, and we'll get you back here soon, probably in person, which was the goal today, but that didn't work out, to talk about bond in your case, okay?
Yes, sir.
I'm going to move you and Mr. Howell into a breakout room. You'll be able to speak privately with him. He's going to be sitting in the jury room. When he comes back out here, if there's enough time, we'll talk about bond, okay?
All right, thank you, sir. Can't see nobody but myself, though.
Did the Van Arsdale family have to leave?
No, they just wanted to sit in they're ready to make statements. They want to be present for everything.
Okay.
So how long do we have?
I'm getting up and leaving at 1 minute to noon.
Okay.
So if you don't think we can do it, they're connecting, and it's good that they're connecting, but we may just have to call it off. It's not your fault that we're starting this late. So I don't want to cut anyone short, and it doesn't make sense to do half a bond hearing.
No.
And I'll be back at 1. I'll be here all afternoon, but he's got to go because, of course, it was a 9 o'clock calendar.
He was doing a favor.
Yep.
Yeah, we only got.
That's slow. What time is it really?
That's
Oh, that's accurate. Okay, that's pretty accurate. Okay, cool.
I finished it.
Whatever. So we got about 25 minutes. If we started right now, but let's see when Mr. Howell comes back. Ms. Jones, you're about 2.5 hours late.
I didn't know I had an appearance this morning. I called, a lawyer, and I spoke with the lawyer last week, and he said that there was no date showing. He said that there was an October date, there was no July date. And I called this morning, I had been calling this morning, my daughter called, they said there was no date, and then when I called back, they told me it was a date at night.
Okay, well, I need you to come back at 1 today. So you can take a lunch break, be here at 1. We'll make sure Mr. Wooten is here and we can talk about next steps in your case. Okay? Huh? So I'm not sure we'll do the bond hearing. We're running out of time. Mr. Marriott. Need to mute your phone.
Oh, I'm sorry. I'll just leave.
You ready to go?
I am.
Okay, I was just explaining to the Van Arsdale family, we'll start the hearing. We're stopping at 11:56 on that clock. If we don't finish, we'll pick up when we can, but we've got everyone, so we might as well start. And we'll see where we go. Okay? Mr. Marriott, let me get you out of the breakout room. All right, Mr. Marriott, can you hear me?
Yes, sir.
Great. You're back in the main courtroom. I'm going to add you to the screen, your lawyer, and the prosecutor. So we've got all the folks here. We're going to get on the record. This is 25 SC 003 438. And it's Damari Marriott, supposed to be here in court today. We had a little transport hiccup, so he's appearing virtually from the jail. And one of his lawyers, Mr. Howell, is here covering for Mr. Apt. Mr. Apt has a conflict as well. And Mr. Apt had filed a bond motion, so we're going to start our discussion about bond and see where we get. Mr. Howell, what do you want to tell me about your client and his fit for bond?
Your Honor, Mr. Marriott is 20 years old. He was arrested April 10th, 2025. He is a lifelong resident of Georgia prior to his recent move to Florida. He moved down in 2024 in order to get his GED and meet his grandmother and start a new life down there. If released, he could live with his father in Powder Springs. He has numerous aunts and uncles here in Georgia. His father is here today, and he is committed to ensuring his son does not abscond or otherwise follows all orders of the court. His previous employment history, he is young, he is 12 years old, but prior to his move to Florida, he had worked as a warehouse worker. He had worked at Wendy's in 2024, and then prior to that, numerous jobs in and around the Atlanta area. He has numerous ties to the community, again, through his family and his very long-term residence here in the Atlanta area, where he attended high school with Leagues next.
What high school?
Hillgrove.
Okay. Where was Hillgrove High School, Mr. Marriott?
It was in Powder Springs, sir.
Okay. Do you have any kids, Mr. Marriott?
No, sir.
And it's your grandmother who's down in Cutler Bay?
Yes, sir.
All right. We do have someone from pretrial on the call. Do you have any criminal history information on Mr. Marriott?
No, sir. I only got locked up.
Oh, I'm sorry. I'm not asking you, Mr. Marriott. I'm gonna hear from the person from pretrial.
2 cycles. Can you hear me?
Yes, sir.
2 cycles, no felony convictions.
Got it. Thank you. All right, Mr. Hiles.
Computer just. So, Your Honor, I do recognize that the defendant does not have hardly a criminal history at all. However, Your Honor, the facts in this case are overwhelming, and let me lay out a little bit of what's going on here. So,
I'm gonna interrupt you for a quick second. I just want to confirm, Mr. Howell, you don't have any discovery, and that's not a knock on anyone. You are hitting this case about as cold as can be. One, not your case, it's Mr. Apt's, but I think we're early enough in this process. While Mr. Apt has opted in and waived arraignment, no discovery that you're aware of has changed hands.
Correct. And just to preface what I believe we're about to hear, I would object to anything that doesn't go to the AALA factors. I believe what the state's going to go into is probably more relying on, well, this is a slam dunk case, or this is the strength of the evidence. And I don't believe that's relevant in this type of hearing. It may be relevant in the civil type of preliminary injunction hearing. AALA is not for pretrial punishment.
Okay, no, I appreciate that. And I focus less on strength of case than just some of the allegations in the case, so I can make my own determination about risk to the community. So I'm gonna let Mr. Hiles share what he wants to share about this, but I'll be mindful that whether it's strong or weak is less of a point than does it seem serious enough that either bond doesn't make sense or it needs to be this size bond versus that size bond. Okay, back to you, Mr. Hiles.
And my counter, thank you for letting me speak. My counter, though, is that likelihood of conviction does go directly to threat to flee when it's a sentence of life.
Okay, I'm gonna let you present what you're gonna present.
All right, so, Your Honor, Mr. Marriott was friends with the victim in this case, Monty Van Arsdale. They had a falling out sometime in 2023. Mr. Marriott, on multiple occasions, told different individuals, and this is coming from his phone dump and his Instagram extraction, that he plans to, quote, take down Mr. Van Arsdale, the victim in this case. And on December 9th of 2024, Mr. Marriott sends an initial text message to the group of individuals charged on this indictment. Who's looking to take somebody down? I got someone who we can steal his weapons. He then creates a group chat and includes Mr. Van Arsdale on that group chat and says, we're looking to trade some guns. The members that we've alleged to be part of four-way, along with Mr. Van Arsdale, start trading pictures of guns and talking deals. And
it's just Mr. Van Arsdale on one side, so one potential gun trader, and then all these four-way people on the other, or?
So Mr. Marriott creates a group chat that includes himself, Mr. Van Arsdale, as well as all the individuals in four-way.
I followed that, but.
So there is.
So it's sort of 8 people negotiating with one person.
Yes.
Okay, that's what I was getting at.
Yes. And a date and time is set up, but then there is a direct line of communication between Mr. Van Arsdale and Mr. Marriott. And Mr. Van Arsdale is expressing his concerns of driving to Atlanta for people he doesn't know. Throughout that concern,
Mr. Van Arsdale's coming from where?
I think Powder Springs, but on the December 9th
he says he's coming from North Carolina. That's what the message is saying. But he is hesitant. He resides in Powder Springs. Is hesitant to come down to inner city to by himself for a weapons deal. All the while, Mr. Marriott is reassuring him that everything is fine. And then he is on the other line of communications, is in a group chat with the four-way members that Mr. Van Arsdale is not a part of, talking about how he's a sweet N-word from Cobb County. He ain't got no street smarts. Don't worry about him doing anything funny. And in that text exchange, it is floated from Jadon Chambliss, what if we just trade weapons? And it is explicit, all caps, I need him taken down, no trades. This particular weapons deal never happens, even though Mr. Marriott is sharing his location, with Mr. Van Arsdale, Mr. Marriott sharing locations with each other, which is simultaneously being sent to the group of four-way members so they can track his movements, where he is getting closer to the city. Mr. Van Arsdale ultimately gets cold feet on December 9th of 2024. Then, same group of individuals with Mr. Marriott initiating the conversations begin to set up a marijuana deal.
With Mr. Van Arsdale?
With Mr. Van Arsdale.
So now it's weed, not guns.
Now it's weed and not guns. Still in one text chain, there's a text chain with Mr. Marriott and the four-way members that Mr. Van Arsdale.
Mr. Van Arsdale would be selling marijuana to the four-ways?
Yes.
Okay.
He did. He absolutely was agreeing to sell marijuana. He did bring marijuana.
And this is now on the 29th?
This is now on the 29th
Okay.
of 2024. And he was given a location off of in the area of Gun Club Road on Washington Street, and lured to the area. All the while, he's still sharing his concerns with Mr. Marriott about dealing with these individuals that he's never dealt before, while Mr. Marriott is encouraging him to go through with the deal, saying it's easy money, nobody's going to try to take you down for this small amount of marijuana. And then, again, having a simultaneous conversation about the location, timing, and when the victim's supposed to arrive. When the victim arrives, he is ambushed, gunned down, and his belongings stolen from him. Shortly after the murder takes place, before it has even hit the news, Mr. Marriott calls the Van Arsdale family, specifically Leah Van Arsdale, and says, I think Monty's been shot. I know some people that are talking about it. I got to get with the people he was with. And alludes that he has information before the police have even identified the body that was on scene. After he was led on, the Van Arsdale family are able to figure out where the body was transported, and it came to light that he was actually killed. So then there are several Instagram threads that continue days after with the people that were involved, consistently making jokes about the death of Monty Van Arsdale, calling him soft, got what he deserved, he was weak, he was from up north. And then on January 6th of 2025, over Instagram, the defendant is directly confronted by a mutual friend stating, "You're the reason that Monty was killed." And he laughs and says, "Your partner died, now I'm a bitch, okay." And then the response from the friend is essentially, you were the main reason he died. And the response from Mr. Marriott is, quote, LOL, I'm the real reason your man's in heaven. If you really think about it, even your partner said you a rookie. Additionally, on January 7th, a direct message was sent to a close family friend of the Van Arsdale, specifically stating, you need to stop talking or you're going to wind up with Monty.
Direct message from?
It was a direct message from Marriott to the family friend of the Van Arsdale family, which was immediately communicated to the Van Arsdale's family. Speaking with the Van Arsdales, they believe truly that there's no way you could communicate with this individual without the intent of having the family know about it, that close of a family friend. Before he moved to Florida, he was living within a 5-minute drive of the Van Arsdale's family. The Van Arsdale's family had welcomed Mr. Marriott into their home. And all of these actions just show the callousness of the planning and the intent. And I feel that they make him, one, a danger to society, a threat to intimidate witnesses, and also the fact that he has moved to southern Florida. That really takes away the ties that he has to this community. And if
Right, but he'd be staying, I mean, if there's a bond, it's an ankle monitor, it's stay with dad, unless dad lives anywhere near the Van Arsdales, in which case it's don't stay with dad, but it's don't stay down in Florida, it would be stay local.
Right. I understand what you're saying, but I think it creates ties to an area of the country that's easy to flee to and easy to get away from. I would argue that he is a threat to flee. The strength of the evidence makes him a threat to flee, especially considering that if he's convicted, it's a mandatory life sentence. And additionally, I mean, just going through his Instagram, it's replete with drugs and weapons and the selling and exchange of drugs and weapons. Even though he's not charged with that, that goes straight to his, threat to reoffend. He just hasn't gotten caught yet. And so I think he is a danger, and we would ask that you deny bond.
Is he currently in a no bond status?
Yes, he was indicted at around the 60-day mark of incarceration, so there's no issue of being held prior to being legally entitled to a bond. That being said, we just ask that you deny bonds on the grounds argued. We do believe at least 2 members of his family would like to address the court.
Okay, why don't we do that? Good morning.
Good morning.
Tell me who you are, please, and your connection to Mr. Van Arsdale.
My name is Elisa Van Arsdale, and I'm the mother of Monty Van Arsdale.
Okay.
This situation has completely traumatized my family, my daughters, my husband, and myself. And it is correct that Mr. Marriott has been to my home, which makes it even that much more traumatizing that he was a associate or a friend of my daughters and my son. I am vehemently objecting any bond so that my family does not have to be further traumatized with seeing him amidst the community. They did go to high school together. His father lives within walking distance of my home. And quite frankly, I just feel that with everything that we have had to endure for the 6 months, my son is not here to defend himself. My son also is 19 years old when his life was taken. And I completely object to having Mr. Marriott be amidst the community. His friends, it's too much of a community tie. We've been in the community for over 25 years. Mr. Marriott is, I believe, newly in the community since high school. And we do not want him to receive bond.
Okay.
Because of what has taken place and what has happened. We're suffering traumatically and trying to pull our lives back together, man. I don't see how life can ever be the same without, he was my only son. And just with evil intent, even afterwards, and the comments and the social media and the things that we have had to be exposed to, what was said afterwards with no remorse, almost a high level of satisfaction that my son is no longer here, speaks to the character of the individual who I feel, and with what has been told, is the reason why my son is no longer here. So I'm asking the court to please deny bond.
Thank you for being here. Mr. Howell, was there someone else, or did that sort of cover things for the family?
I think we're good.
Okay, I appreciate that input. Mr. Howell, I want to give you the last word as the movant. I know you have zero information about the case, and I get that, but you know a little bit about Mr. Marriott and his situation. So if there's anything you want to add or reemphasize, I certainly want to hear that.
Just argument about the law and application.
Okay, I'm ready.
You know, the most fundamental premise of our justice system is that a person ought not be punished for a crime until the state demonstrates guilt beyond a reasonable doubt. Unless this right to bail before trial is, preserved by courts across the state, that right to the presumption of innocence would lose all of its meaning. We don't have much information now. Will we be able to deny what the allegation? When looking at reading over Ayala, which I always read over before I go on your motion, even though I've already given you talk about the risk of flight, the danger to the community, the risk of committing additional felonies, risk of intimidating witnesses. What we're doing is in reality, we're balancing the equities, the state's interest in protecting the community versus my client's interest in justice. If you read Ayala and the progeny and the other cases that have come out of it, and cases from other jurisdictions as well, really the amount of bond is what secures the defendant's attendance at trial. The conditions of bond are what protect the community. I believe that there are reasonable conditions that protect the community. The state alleges that the majority of this, their evidence shows that they've been directed and they were done electronically. Well, we ban his use of a cell phone. We can ban his use of a computer. And the court order that he can't contact anybody like that. Risk of flight, that can be alleviated through an ankle monitor in the amount of risk of intimidating witnesses. Again, same thing. Court could order no contact. I believe, given Mr. Marriott's criminal history, which there is none, no convictions, that he's an excellent candidate. The way I like to put it is, I remember the first time I graduated law school and I had zero in trying to go buy a car. Well, you just have to put faith in the borrower that they're going to be able to pay it back. I think Mr. Marriott's lack of criminal history shows that he's a good candidate, and this faith in him that he's going to pay back by showing up to court and obeying the court orders. Therefore, I believe that the court should set a reasonable bond.
All right. Thank you, Mr. Howell. Mr. Marriott, do you have any questions about anything we've discussed so far?
Yeah, I really do want my discovery pack, sir. That's all.
I didn't say. Oh, discovery packet. Great, because that's where I'm going. So, Mr. Marriott, at this point, I'm going to leave you in a no bond status. I very much understand Mr. Howell's perspective, and I thought carefully about each of the factors. I think your move to Florida is a cause for concern. I appreciate that you've got family here and connections here. But that happened so close on the heels of this situation, whatever your connection to it, that it does make me nervous about making sure you'd be back in court. I also have some concerns about what would happen with people who know about this case and an ability to keep the Van Arsdale family insulated from how you feel about this case and where it might go. And so for now, I'm going to leave you in no bond status. But to your question about discovery, the state will be providing discovery to Mr. Apt in short order. There's a lot of discovery. There are phone dumps. There's this and that. They'll get it all to Mr. Apt. He will get it to you, that which he can get to you. He can't give you a CD with a bunch of pictures on it or text or this or that. He can print stuff out, but he's going to need to arrange for some contact visits with you so you can look at things on the computer. But importantly, I am inviting Mr. Apt, whether it's through Mr. Howe or it's Mr. Apt directly, to ask for reconsideration after he's had a chance to review the discovery and you have as well. There are at least two sides to every story, and I appreciate that I have heard the state's rendition of what happened and who said what to whom and what certain things meant. And sometimes that's exactly what the evidence shows. But other times, once the defendant and his lawyer have a chance to look at the evidence and we get back together, things are shown to me in a different light, and I can be more comfortable that there would be a set of conditions of bond that would ensure you show up, number one, ensure that the community is safe, number two, and ensure that there isn't any risk that you're going to get back in trouble, whatever your cell phone traffic shows. But right now, I don't have that comfort level. So we're going to keep you where you are. Mr. Apt will come see you with the discovery, and we'll take this back up at the appropriate time. Mr. Hiles, anything else from the state?
No, Your Honor.
Mr. Apt did file a waiver of arraignment, so I know we're in flux with, is there going to be a new indictment? But if you could begin through your paralegal pushing discovery out, that'll address Mr. Marriott's immediate request.
I can do that.
Okay. Mr. Howell, anything else on behalf of Mr. Marriott?
Nothing further.
I appreciate your patience today. Should have been able to do this at 9 and here it is noon. So you spent the morning. I hope Mr. Apt takes care of that for you.
It's part of the job.
Okay. Mr. Marriott, I will see you again once Mr. Apt has gotten that discovery. He will file some other motions, I suspect, and he may well file a motion to reconsider bond. We'll get you here in person so you don't have to be in that booth next time, okay?
Yes, sir.
All right. Thank you, everyone. And thank you, Ms. Alexander, for getting Mr. Marriott into the booth on short notice.
No worries, Judge.
All right. So we're down till 1 o'clock. We'll pick up with our final plea calendar, and we had someone come in late from the morning calendar.
Thank you.
Thank you, sir.
Yeah. Take it easy.
Yep.
It's good to be here.
All right, good afternoon, everyone. Sorry for the later start. This morning was special. But we are back on track-ish. We have a final plea calendar. If your case is on the calendar, you are likely on the August trial calendar. I think there's one exception when we get to Anthony Johnson. But most folks are on the August trial calendar. Today is a day if you're going to resolve your case short of trial and want to be able to withdraw your plea. If you don't like the sentence you get, you can do that through today. After that, you won't be able to withdraw your plea if you're unhappy with the outcome. Did Ms. Jones come back? She did come back. Okay, we'll get to you, Mr. Wooten. Thank you for coming back. Ms. Jones made it in here around 11:30. Something about not getting notice, but we'll work through that when we get to it. Position 1 is Philip Johnson. Ms. Rios, you're here. Good afternoon. What are we doing with Mr. Johnson today? Great, we'll get him out here shortly. Next up is Shelby Gardner.
Good afternoon, Your Honor. John Tate, Ray Gordon. And this will be the first opportunity we've had to discuss any.
Well, let's start with the basics. Where's Shelby Gardner?
She's present.
Oh, right there. Good. Okay, that's the most important part. First time to discuss what with whom?
Any type of plea offer.
Okay, so up till today, you had not received one from the state? Okay. Ms. Clark, any reason why the defense attorneys, and they've been active in the case, there's a general demur that sort of sounds like a special demur, but it's filed as a general demur. You've responded. There's been a reply to your response, but they're saying no offer from the state.
Right, Your Honor. So the reason I'm still waiting to receive the medical records on the case, but I had intended on, the state intends on submitting both of the defendants in this case to the Family First program. It's a diversion program, but it's in making a conditional plea offer. But I needed to basically speak with counsel to get that.
Okay, well, why don't we do this? I'm gonna finish calling the calendar, there's not many more positions, and then why don't the three of you have an initial conversation? At a minimum, what I would do is preserve Ms. Gardner's final plea rights. We'll keep this on the trial calendar it's scheduled on, but I preserve her final plea rights so that if there is some back and forth someday before that trial calendar, if we needed to get together to see if it's going to be a plea, we could do that. And Ms. Gardner would still have the ability to withdraw her plea if the way that went was different than what you had advocated for. Ideally, you would have received an offer by now, and so we'd have a back and forth about that, but I can't force the state to do that. I just won't compromise Ms. Gardner's, it's not really a right, but in this courtroom, it's an opportunity to be able to withdraw your plea if the sentence you get is more severe than your lawyer asks for up until that final plea date. So we'll just make the final plea discussion run all the way through the call of the trial calendar. I owe you a ruling on the demurrer. I'll give you a preview. It will likely be denied. A general demurrer is one that basically says my client could admit to what's in the indictment and not be guilty of anything. And as I read the indictment, that would involve Ms. Gardner admitting that she fractured the femur of the child, and certainly that's a crime. I know there's a little bit of a date range in there, but it's basically an overnight type date range, and that didn't seem to me to rise to the level of there needing to be anything more from the state. But that's my provisional ruling. I'll cement that. And it may be moot if things are trending in the direction that Ms. Clark described. Ms. Clark, you don't have medical records yet, but Ms. Gardner was arrested in 2023. So a year and a half ago. When do you think you'll get medical records?
Your Honor, I plan to have them by the end of the week.
All right. So I'm going to ask you to stay and at least have a initial conversation with Ms. Clark, and then let's talk one more time before you do go for the day, so I have a better sense of where things might be going. Does that work?
Certainly, yes, Judge.
Okay. Appreciate your patience. All right. The co-defendant is Roderick Foster. That's your client, Ms. Rios, and he's here. He just stood up. Good morning, good afternoon, Mr. Foster. I heard Ms. Clark say she's thinking about the same recommendation for both individuals, but I'm guessing she still doesn't have medical records since I last asked.
We talked, we came on the bench and, yeah, I'll just have to wait on it, I guess.
Okay, so same thing, we keep Mr. Foster's final plea rights open. Are you going to be talking more with Ms. Clark today, like counsel for Ms. Gardner, or what's the plan for today? And I ask only so we know what to do with Mr. Foster. If there's not going to be any further discussion that he ought to hear the results of, then he doesn't need to stick around. Ms. Gardner should certainly stick around until her lawyers are done speaking with Ms. Clark.
So she can actually refer to her line.
Okay.
I just need in the, if you'll email me his full contact information to include address, email, and phone number. Let me have him stay, so I can.
Okay. Mr. Foster, you can take a seat, and please don't go till Ms. Rios says you can go. Thank you. Tremaine Denson. Mr. Denson, your lawyer let me know that he has a conflict, so he can't be here. You keep having ankle monitor problems. I'm going to take away your bond if you can't figure out what's going on with the ankle monitor. You don't have an ankle monitor anymore?
Yeah, I do, but we talked about it.
I know we talked about it, and then I got another email from Second Chance. I'm going to find it right now. But that's why I wanted you to show up. Otherwise, I would have excused you as well, because we got to figure out. I was a little leery about having you on an ankle monitor. I mean, not revoking your bond. Let's see, June 18th. Do you have a curfew, or you're supposed to stay away from places? Or both?
I have a curfew, but I have a job, so.
You do have a job.
I sent them I sent them several different documents.
Well, they had you in Bethlehem, Georgia at 2:30 in the morning. So I don't know what kind of job takes you to Bethlehem, Georgia at 2:30 in the morning on June 17th, but that doesn't seem like a.
No, I'm a toll operator, so I work at night.
Okay. Bethlehem.
It's like 45 minutes away.
Yeah.
It's a toll truck yard out there, and I can, on my email and get like my scheduling and all that, pull up receipts. I keep them and send them different documents. I mean.
So you think you might have been in Bethlehem, Georgia at 2:30 in the morning for work? You know. Okay. Well, why don't you send them some kind of documentation about that?
I did, but she said once it's sent to you guys, they can come to court with me and rectify it, but once it's sent out, it would have to be up to y'all, and they can go to the court and tell y'all that I rectified the situation.
Okay. So you're saying if I reach out to them, they'll say, oh, we got something from Mr. Denson showing that he was towing a car in Bethlehem, Georgia at 2:30 in the morning. Okay. You talked to them, or you gave them some paperwork?
Yes, I sent an email. I have email, proof of emails, all of that, because one time my ankle monitor was going dead, and they called me like, I feel like violating, so make sure you charge up. And I was like, okay, let me make sure I got my I's across my T's, because some people wake up with different moods every day, so I mean, they might violate me for nothing. So, I mean, I be doing what I have to do, but I mean, it's kind of hard. If they're gonna, like, I really don't do anything but go to work.
Okay. All right, well, I'll check with them about Bethlehem, Georgia at 2:30 in the morning. Your final plea rights are preserved, but you are on this August trial calendar, so you'll need to be back here with Mr. Smith if you and he have not worked your cases out, okay?
Is there anything you can do about my curfew?
So that's a fair question. You should talk to Mr. Smith about that because he would need to make the formal request and he'd certainly want to talk with the prosecutor as well. Ms. Davis, this has your name on it, but I feel like it would be Ms. Dilligard's case. I'm remembering these cases and it's a colorful set of facts with an interesting victim defendant situation.
Correct, Judge. And I spoke with Mr. Smith yesterday. I did relay a preliminary offer. We are still trying to make contact with the victim. And so my team's working on that. I anticipate, and I shared this with him, that it will resolve maybe a little bit less of what I've offered yesterday once I am able to convey that to the victim.
Got it. You just need to make that connection.
Yes.
Okay. So Mr. Denson, things are trending in a good direction for you, but talk with Mr. Smith about modifying the curfew. He may give you an update based on his conversation with Ms. Dilligard and tell you to sit tight, or he may say, great, we'll send something to Judge McBurney and I'll certainly look at that. Okay? All right. You do not need to stick around because Mr. Smith's not going to be here. Okay? You too. Drive safely. Tanaya Tillman.
She's on Zoom, Judge.
Yep, I see there's a Tanaya.
I'm sorry. Okay.
There she is. Hey, Miss Tillman, how are you?
I'm good, thank you. How are you?
I'm okay. Ms. Wood, what are we doing today with Ms. Tillman's case?
The misdemeanor plea today, Judge.
Okay. Ms. Tillman, you're welcome to go back on mute and camera off. We'll circle back shortly. It sounds like your case is working out today. India Albert, I was told, would also be on Zoom.
Good afternoon, Your Honor. Brandon Rosen with Miss Albert, and I believe she's on the Zoom as well.
All right, let's see. Yep, there's Ms. Albert. All right. What are we doing today, Mr. Rosenblum?
My partner, Mike Barber, and the state worked out a plea offer that my client is willing to accept today.
Okay. Ms. Dilligard, your case? All right. Is it your understanding that it will be a plea?
Yes.
Great. Okay, Ms. Albert, we'll circle back in just a few minutes and take that plea. Mr. Rosenblum, you're in for the duration, or is Mr. Barber coming on later?
Your Honor, I argued with Mr. Barber about him taking this case, and I said, no, I'm doing it. So I'll be here.
Excellent. All right, we'll circle back in a minute.
Thank you, sir.
You bet. Ronald Lawson. Hello, Mr. Lawson. All right. Plea today, Mr. Lawson. We'll get you up here in a minute. Avion Hernandez. Let's see if I have notes on this one. Nope. That's Ms. Cabrera's client, I think. Jeremiah Hernandez. Try that. Nope. All right, I'll call it again, Ms. Davis, in a little bit, but if he doesn't show, bench warrant?
Yes, Judge.
Okay. Jessica Jenkins is online. I see her there. But I have notes. Your lawyer, Ms. Jenkins, can you unmute?
I'm here, Your Honor.
He's on Zoom.
Oh, he's on Zoom. All right, I heard he was on leave.
I am on leave, but I'm here.
All right, way to do it. Well, I appreciate that, Mr. Smith. I don't like impinging on lawyers' leaves, but here we are. What are we doing today in Ms. Jenkins's case?
Your Honor, Ms. Davis has indicated to me that this case is going to be referred to diversion. Of course, that doesn't necessarily mean acceptance, but if we are accepted into diversion, then we would like to have that opportunity to do so.
Okay, Ms. Davis, where are we in the diversion pipeline?
We're at the beginning stage, Judge.
The beginning stage. Okay. Well, I just saw Ms. Toole. She says the pipeline moves pretty quickly. So you'll be submitting the necessary paperwork?
Yes.
Then why don't we do this, Mr. Smith? We will keep Ms. Jenkins on the August 7th trial calendar. We will preserve her final plea rights, and hopefully all that will be unnecessary because diversion will work out. And we don't need to wait till August 7th. I will be bugging Ms. Davis to make sure she's put in the application. And if we get the green light, then Ms. Davis gets to me an order that puts Ms. Jenkins's case on judicial hold during the time she is meeting the requirements of the diversion program.
Yes, Your Honor, that'd be great.
All right, Ms. Jenkins, have you had an opportunity to discuss with Mr. Smith the basic outlines of what diversion is all about?
Briefly, I would like more information.
Okay, well, he'll give you more. I just will give you a quick sketch, which is that for 6 to 12 months, you're given 12 months to complete everything, but if you get it done in 6 months, we can end it early. But there's some community service, there's some educational component, obviously stay out of trouble while you're on it. But it is all designed to keep you heading in whatever good direction you're hopefully heading now. And if you successfully meet all the requirements, then the state dismisses your charges.
Sounds good. Thank you, Judge.
Okay, Mr. Smith will get you the details because he actually has to sign off on them on your behalf. But Ms. Davis, the prosecutor, is going to confirm that you qualify for the program, and we'll take it from there. So I may not see you again. If you are admitted into the program and you successfully complete it, it's all paperwork based. If there is a hiccup or you're not accepted into it, then that increases the chances that we'll be together sometime, okay?
Okay, just thank you.
All right, Mr. Smith, anything else on behalf of Ms. Jenkins?
No, Your Honor, thank you so much.
All right, are you on leave as in you're in a fun, exotic place, or are you just at your house?
Well, while everybody took their vacations on the beach for the 4th, I work. So now it's my turn to go to the beach and have a good time. So I'm headed to out Midwest, and then I'm headed down to Florida for my family reunion next week. So
Excellent. Well, enjoy the family reunion. I don't know about Midwest, but family reunion will be nice. And I appreciate you working for all of us over the 4th of July.
yes, Your Honor, thank you so much.
All right, you and Ms. Jenkins are free to go.
All right, thank
Thank you, Judge. Have a good day.
All right, you too. Anthony Johnson, I don't know that he needed to
He's on Zoom.
be here. Okay.
Good afternoon, Your Honor.
Hey, Mr. Johnson, can you turn your camera on? There he is. You have another case, Mr. Johnson, that is already heading towards the September trial calendar. And so is the thinking, Ms. Wood, that when we do final plea for that case, we do final plea for this case? Or was today supposed to be final plea for both cases?
Judge, I'm not sure. I do know that I'm trying to resolve all 3 at once.
Well, there's 3 cases?
Yes.
Okay.
And I think,
Is one not indicted yet?
so it was originally.
Is this the guy with all the carjackings, but I can't revoke his bond because the way they happened and when he obtained bond, nothing violated his bond.
As much as I know you want to revoke.
I just don't want him to take anyone else's car, allegedly.
Allegedly.
Yep.
So I was gonna ask if we could just keep it on the September trial calendar. I'm hopeful that we'll have a resolution well before that.
That's already happening, not necessarily the resolution, but Ms. Nelson told me that this case will go to the September trial calendar. My question, I didn't ask it well, is there going to be another final plea that the other case, they're sequential. So 872 is on the September trial calendar. 873, the one that's on today's calendar, I'm told is going to that trial calendar as well. But 872 wasn't on today's final plea calendar. So I don't know that we have another final plea date for Mr. Johnson. I guess we could just keep final plea open and say, we'll see everyone at the latest for that September trial calendar. Okay.
Thank you.
Ms. Davis, does any of that trouble you?
No, Your Honor.
Other than the fact that there wasn't a bond revocation in there?
No, Judge, it doesn't.
Okay, what's the third case?
It's hijacking. I believe I indicted these cases, Judge.
Okay, but the third one, let me see if it's,
They all have to.
there's a 24 SC.
Yes. That was the original one, and then these two were delocked at preliminary hearing stage.
Okay, right, this is the same officer and they couldn't get him to show up.
Correct.
Come on. Okay. All right, I see a pattern. Hey, Mr. Johnson, you got any questions?
No, Your Honor.
Okay, you will be here in person, not on the phone, wherever you are now, on September 25th, if we don't get together before then to resolve your cases, okay?
Okay.
All right, Ms. Wood, you good with discovery on these three cases? I've been forgetting to ask folks about that, but here we are. All right, we'll keep final plea rights open, and if things are not resolved before the 25th of September, we'll get everyone in here and handle the final plea process and trial calendar call. All right, you bet. Mr. Johnson, you're good to go.
Thank you.
Zachariah Williams.
Judge, who's mine? Oh, there it is. I'm going to convey an offer, so if I can speak with him after the calendar.
You guys will talk. Got it. Okay. Anthony Smith. Hey, Mr. Smith, your lawyer is in trial right next door. Oh, Mr. Kane's your lawyer now?
Yes, sir.
Oh, all right. I had Ms. Cabrera listed as your lawyer. How long have you had Mr. Kane as your lawyer?
What time?
Today?
Yes, really, this is my first time really come to court on paper.
Okay. Hello, Mr. Kane.
Nice to see you, Judge. How are you?
Better now that you're here.
Have you changed the lighting or am I just?
It is. We got a refresh. But now that you're here, maybe it should be more like, oh, yeah.
Lighting.
Daniel Kane is in the house. Uh-huh.
This is much better. Yeah, absolutely.
On the resolution.
Okay. Mr. Williams, no, Mr. Smith, is telling me that, you are newly on the case.
Well, let me, if I may. I am not newly on the case. Mr. Anthony Smith came to my office 75 minutes ago.
Okay.
And the case did not appear to me to be on the rail. I don't have a lot of, I didn't accept the case, but I told him I would come down and speak to you. And if I could make some sense out of it, I would file a notice of appearance.
Okay.
I think currently the public defender is representing him.
He has the conflict defender, but yes, the public defender may be representing Samantha Beck.
Yes.
Yes, is Ms. Fletcher here? She's on Zoom. So co-defendant is on Zoom. Mr. Smith is right here. And I'm trying to figure out why I have this case. It got transferred from non-complex recently.
It's a little confusing. It's a shoplifting case. It may be 2 counts, I'm not sure.
It is.
And he's been recidivized under various code sections, 3 of them. So without any discovery, without seeing the indictments, I didn't want to formally, just only come down and speak to you, see if you could get some time to sort the matter out.
Is it your sense that he is in a position to retain you? Because what I want to avoid is you decide, yes, you'll take it. He says, I want you, and yet you can't make things work out.
Well, that's federal rules of criminal procedure 1, and I guess state criminal procedure. I didn't take any monies. He said he can retain me.
Okay.
So based on his representation, yes.
Okay. Let me. So
Can you also check to see if discovery has been served?
it has. He has a lawyer, and she filed a notice of conflict because she's in trial. So that doesn't mean he can't bring someone on board. But what I don't want to do is this sort of, well, I want to delay things, so I sort of have a lawyer, then I don't. I'm going back to this other lawyer. What kind of paperwork would help you?
How about if I've heard you mention you just keep the final plea open and proceed to the trial panel.
Yes, we can do that.
And I don't know if there's been a plea offer. I don't know. I understand he has not reviewed the discovery. I don't think he understands the recidivist notice, which needs to be contained with thorough.
Okay, fair point. It looks like some discovery was provided, but that was back when it was in non-complex, so who knows where that went. My guess is discovery wouldn't be too voluminous in a case like this.
We could just interject here.
Please.
I don't know why, this case already had a final plea in non-complex on June the 9th, and then it was sent to us, so this is actually this case's first time on our calendar.
Okay. So we probably need to bake in a little more time for everyone, not just Daniel Kane.
I appreciate that. But thank you for volunteering information, because I couldn't make sense of it when I looked at the clerk's calendar. That's why I said the case is not, it appears to be off the rails. So,
Yeah, that sounded a little pejorative, the off the rails part. So I was gonna ignore that, but
your train is always headed straight ahead on the rails.
on time, every time.
You set your clock.
Not that clock. Okay, so it sounds like we ought to confirm, well, there was a certificate of discovery, but that says initial discovery. Let's see. Yeah, Ms. Davis did push stuff out, but that would have been because it landed in her lap also late in the game. So it looks like there's some documents, videos, images. Those were sent to Ms. Cabrera. There's not a trial date yet because this just came to us from non-complex. My thought would be to give everyone enough time. We put it not on the August trial calendar, but the September trial calendar. I can do a mini scheduling order, but it would basically be, Ms. Davis, please send discovery out, which she's already done. She'll resend it to you, Mr. Kane, if, capital IF, you file an entry of appearance. Otherwise, Ms. Davis has provided discovery to Mr. Smith's counsel of record. But I'm also understanding him to say, I've never met my counsel of record. Because the train maybe was wobbling a little bit, still on the rails, but wobbling a little bit. So we can build in a little time.
Yeah, maybe just go right through.
Yep, right through the semaphore.
Could I get Ms. Davis's first name so I can get an email?
Rashida, Rashida.
She might even give you some contact information because we're done calling the calendar. And so then we can figure out what our first plea is going to be, et cetera. Ms. Fletcher, can you You are. Great. Let me get you on the screen as well. Have you been following some of this conversation? It's your case too. You and Mr. Smith are both charged in the indictment.
Yes, sir.
Okay. Ms. Wood, this is your case.
It is, Judge, and I was gonna ask for that reset as well. Just, she has informed me that she had turned over some potential exculpatory evidence to the previous attorney and having a little bit of an issue getting that file from the previous attorney, so.
Someone from your office? Okay, so that's a good sign though. It's your office. But you have information about Ms. Fletcher.
Yes.
You all have connected. Okay. Then why don't we plan to have this case be on the September trial calendar, which is way at the end of September. Mr. Kane, if you file that entry of appearance, that'll be your ticket to discovery. Ms. Davis can just send you the same evidence.com link that she sent to Ms. Cabrera, and then everyone will have a better sense of what this case is and isn't. Let me look at that recidivist notice. Okay. Mr. Smith, do you have any questions? Ms. Fletcher, do you have any questions?
No, sir.
All right. Mr. Smith, did you ever go to court when it was, you're not going to know that it's non-complex or complex, but have you ever been to court on this case?
Yeah, I've been to court, but nothing has happened. I haven't talked to nobody or anything.
Okay. That's not a rare occurrence, but you have been to court a few times, just not this courtroom. Okay. Got it. And Ms. Fletcher, same for you?
Yes, sir.
Okay.
So the party's been arranged.
Let's make sure before Ms. Cabrera waived arraignment and filed her entry in the case already. So you'd be replacing her, but she waived arraignment for Mr. Smith. And let's see if the same is true for Ms. Fletcher. Yep. Someone may have waived for Mr. Smith earlier too, because there is a waiver back in non-complex for Ms. Fletcher. So we're good to go with the arraignment. We'll get discovery out, and it involves two stores I've never heard of, Sac Deluxe and High Stakes Atlanta.
Neither have I.
All right, some fancy handbag. Anything else, Mr. Kane?
Yes, Your Honor, when you leave the bench, I'm going to speak to counsel of the state, get contact information.
Great. What is a reasonable time frame to give you and Mr. Smith to decide if you are going to consummate the business relationship? A week? 75 minutes wasn't enough.
I was overwhelmed.
Okay. All right. I will have Ms. Nelson circle back with you early next week to see what's happening with representation. And Ms. Wood, you're good to go with Ms. Fletcher, September 25th trial calendar. Ms. Wood, anything else on behalf of Ms. Fletcher?
No, Your Honor, thank you.
All right. Ms. Fletcher, thank you for dialing in. You are good to go.
Thank you.
And Mr. Smith, you can go when Mr. Kane says you can go. He's going to stick around just to get the contact information of the prosecutor. Good call.
Thank you.
All right, why don't we talk about Ms. Jones? So Mr. Wooten, you and I, Ms. Jones will talk, and then we can start taking pleas. That'll free up Ms. Davis to meet Mr. Kane. Ms. Jones, why don't you come on up to the podium, please? And Ms. Clark, I think the counsel for Ms. Gardner is still here. If you guys want to go in the jury room.
Okay.
All right. So Ms. Jones, we were in this same situation 30 days ago. And you were going to look into hiring an attorney.
Correct.
So here we are 30 days later. What do you have to share?
I found someone, I've just not retained him yet.
Okay. Someone that you will retain if you're able to, or you know you can retain. It's just, it takes a little while to make that happen.
Correct, that's
Who is that someone?
Christopher Campbell.
Christopher Campbell. And his offices are where?
Not sure.
Well, I don't mean like the street address, but is he in Atlanta or is he in
Yes,
Mapleton? Gosh, there are a lot of Christopher Campbells. Okay. And he has quoted you a price that I'm not getting into any of the specifics, but whatever price he's quoted you, it's something that you think soon enough you'll be able to meet.
Correct.
Okay. What's the ballpark of when we could expect him to, we'll know it's official when he files an entry of appearance.
Yes.
That's the magic ticket. He files that. Mr. Wooten knows this is the lawyer. He has someone to send discovery to start talking about the case with. Is it resolvable? All that kind of stuff. What's a good time frame?
Next week.
Oh, that's soon.
End of next week.
Oh, okay. So you're just like Mr. Smith and Mr. Kane there. You've met Mr. Campbell?
I spoke with him a few times over the phone.
Okay, but you have had contact. Like if I were to call him today, it's like, oh yeah, I know Ms. Jones. We're sorting that out. Okay. So by next Friday, things should be good to go.
Yes. That's the plan.
That's the plan. Any reason why the plan wouldn't work out?
Not that I can see right now.
Okay. All right. And I guess you've taken care of bonds because here you are.
Correct.
All right. Are you back at work?
I am.
Good. Mr. Wooten, anything else we need to cover? I guess you'll be waiting for that entry of appearance. And I'll just make a note, Ms. Jones, to check the docket by the end of next week. And if there's not an entry of appearance, we're gonna have to get you back in here and figure out what we need to do. But you don't foresee any reason why engaging Mr. Campbell would be an issue between now and into next week?
No.
Okay, good. Anything from the state?
No, Judge.
Okay. Remind me, are you related to Kayla Brown?
My daughter.
Any insight on her attorney situation? That got complicated because her attorney is trying to come off the case.
I'm not sure.
You're not familiar with that?
I'm not sure.
Okay. All right. Let me look that up. Maybe that would be a time to get everyone in court. I think that's what you mentioned.
I think it's on schedule now for the 25th, Judge.
Yes, so and that's to deal with the bonds too?
There's an issue with the bonds because the cash bonds were issued under the initial indictment number. There's an issue with the jail with how they transferred those funds to the new.
Okay,
number.
not a revocation issue, it's just we have to structure it. But more importantly for Ms. Brown, it's what are you gonna do about a lawyer? Okay, so I think what I'm gonna do, Ms. Jones, is add you to that July 25th calendar. We haven't even done arraignment for Ms. Jones yet, I guess, because she didn't have a lawyer. So we'll add you to that July 25th calendar. That'll be a chance for me to meet Mr. Campbell. If before that date you've hired Mr. Campbell and you and he talk and he decides to waive arraignment for you, which is just entering a plea of not guilty, then you won't need to come here on the 25th. The main focus on the 25th is sorting out, wait, why is the lawyer for your daughter trying to leave the case? And I just want to make a record made of that. But if Mr. Campbell doesn't think it's a good idea to waive arraignment, or there's no entry of appearance yet, meaning you don't have an official lawyer, you'll need to be here on the 25th and we'll have our own conversation.
Okay.
Does that make sense?
It does.
Okay. So I'm telling you right now, July 25th. So don't come at 11 saying like, wait, what? No one told me. Oh, except that it's funny I say 11. That's when your daughter's calendar is. So you'd be coming at 11. And we'll send a notice out because I'm going to have you included on that calendar. But again, Mr. Campbell may say, don't worry about it. And if your lawyer tells you not to worry about it, you don't need to worry about it. That would be because he waived arraignment on your behalf. He would have reached out to Mr. Wooten and said, look, we're entering a plea of not guilty. And then we'll move the case forward. Okay? Anything else, Mr. Wooten? Do we also need then, will Mr. Jones be showing up? Because he's got the same bond, not a lawyer issue, but a bond issue.
Yes.
Okay. Are you related to Mr. Jones?
My brother.
Your brother. Interesting triangle. Okay. So he'll be coming, is he on that same day?
He is.
Okay. So if you want to see everyone, they'll be here at 11 on the 25th. But you won't need to if your lawyer has filed that entry and he ends up waiving arraignment. Okay? Anything else?
No.
All right, you're good to go.
Thank you.
Judge, sorry to interject. This is Attorney Rosenblum. That's Mike Barber on the Kayla Brown matter, and he is going to be in Japan on the 25th. So I'm hoping that our office did file his leave of absence when we were.
Let me look.
Okay.
Small world.
Small world indeed.
Yep, he has July 14th through August 5th. I think we missed that when we set that calendar. So we may need to reset that. It seems silly to just drag Mr. Jones in. We ought to get everyone in here. He is back August 5, August 6. So we would just push it into August a little bit. Okay, I'll make a note of that. Thank you, Mr. Rosenblum. Good catch.
You know, every once in a while I catch something. It's fine.
Post August 5. You know what? Since you did that, why don't we take your plea first?
Thank you, Your Honor.
Judge, may I have the excuse?
You may. Thank you for coming back. I was a little surprised when someone walked in like, wait, Miss Jones, wait. Deputy Gordon brought up the calendar and pointed to the thing. I'm like, oh, bench warrant, what are we going to do?
We got it resolved.
Yeah.
Thank you. So.
Yeah.
Ms. Davis, is India out? Nope. Ms. Dilligard, you're up. Ms. Rivers, are you ready? All right. Ms. Dilligard, are you ready?
Yes, Judge.
All right, well, we're going to go on the record. This is 25 SC 000-768, State versus India Albert. Ms. Albert is appearing remotely with her lawyer, Mr. Rosenblum, who is also appearing remotely. We have Ms. Dilligard here in court. Ms. Albert, I need you to unmute, please. Can you hear us?
Yes.
All right. I need you to let me know that you are okay appearing virtually today. You have a right to be here in open court, but you can waive that right and appear virtually. Are you waiving that right?
Yes.
You also have the right to have Mr. Rosenblum right next to you, so you can lean over and say, what's that judge talking about? But he's appearing virtually as well. He appears to be in an office with some photos and I'm sure certificates of excellence on the wall. If you need to speak with him privately, we can make that happen. But for now, he's going to be in a different space than you. Are you okay with that?
Yes.
Okay. In a moment, Ms. Dilligard's going to put you under oath. Once you're under oath, you're going to need to answer a whole bunch of questions. I need you to answer those truthfully and completely. If you have any questions of your own, you should interrupt us, and I mean that literally, so that we can address whatever your concern is, okay?
Okay.
All right, Ms. Dilligard.
Ms. Albert, can you please raise your right hand? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct, and legal name for the record.
India Monique Albert.
Ms. Albert, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you did not take today? What was that?
No.
How old are you?
24.
And how far have you gone in school?
Some college.
Do you understand that you've been charged with the following offense? It's 1 count of aggravated assault, family violence.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove that charge against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charge in this indictment to include the facts and circumstances related to the charge?
Yes.
Do you need any more time to talk to your lawyer?
No.
Are you satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects in the indictment for purposes of this plea?
We waive any and all defects and we stipulate to the facts for this plea.
Okay. Ms. Albert, do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for the charge which you're pleading guilty to today? So
Yes.
for the okay, great. For the record, the aggravated assault carries a 1 year to 20-year sentence.
Yes,
Do you
ma'am.
understand? Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the state's recommendation is 5 years of probation for the defendant to complete the family violence intervention program, to complete 50 hours of community service, to get a mental health evaluation and any recommended treatment, and to have no contact with the victim.
Yes.
Is that your understanding of the recommendation, Ms. Albert?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum sentence on this charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
And do you understand that doing so will result in new criminal charges for which you can face a sentence between 1 and 5 years?
Yes.
Are you a United States citizen?
Yes.
Attorney Rosenblum, is Ms. Albert utilizing first offender?
Yes, thank you.
Okay. Ms. Albert, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes.
This means that you can be adjudicated guilty and can be resentenced up to the maximum sentence for the charge in this indictment. Do you understand?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses to include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Ms. Albert, how do you plead to the charge of aggravated assault in indictment number 25 SC 000768?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
And Judge, I believe counsel stipulated to the fact, would Your Honor like me to give a factual basis for the matter?
I just want to understand a little bit since we're going with straight probation.
Yes, Judge.
It sounds like it was a relationship and someone got poked with some scissors.
Yes, Judge. So the victim did get poked with some scissors. However, after speaking with the victim, he did not wish to move forward with prosecution. However, the state did have concerns because there is an open case with the same parties in the solicitor's office where she, I believe, scratched his forehead and threw some things. So we weren't obviously willing to dismiss the case as the victim wished. And because of the battery, family violence, didn't want to reduce the charges. We thought that this would be a good resolution in the matter.
But Mr. Gordon, that's the victim, did he require medical attention as a result of this?
I think he said he had to get stitches to his arm.
Okay. And he is going to comply with the no contact provision?
He should.
As best you can tell, or?
As best as I can tell, I don't believe that they are together, and Ms. Albert can correct me if I'm wrong. But he did express that he was not interested in moving forward with the case, and that they both had been drinking that night, and that he in no way fears Ms. Albert. And so
But he understood that a condition was going to be no contact?
Yes.
Okay. All right. Thank you. Mr. Howard from pretrial, can you share with me any criminal history information you have on Ms. Albert? Please.
Second arrest. The battery DV, she stated 23 CR 007-464J. That's in Judge Besson's court. The last time she went to court for that was May 25th for a jury trial calendar call, but I don't see any notes outside of that.
Okay, and you said just 2 cycles?
Correct. This one and that battery DV.
Got it. Okay, thank you. Mr. Rosenblum.
Your Honor, we would ask that the court accept the terms as negotiated. We would also ask if the court will consider a behavioral incentive date to give her a further incentive to get everything done as quickly as possible.
Okay. Ms. Albert, where did you do some college?
Clark Atlanta University.
How come you stopped?
Financial problems, but I plan on going back after summer, but not specifically to Clark. I'm gonna go to like Georgia State.
Okay. How far did you get at Clark Atlanta?
I did about 2 semesters.
All right. Do you have any kids?
Yeah, I have a son.
How old is he?
He's 3.
Does he stay with you?
Yes.
Tell me what kind of work you do.
I work for West End Hotel downtown. I'm a front desk agent.
How long have you been there?
I'm going on 2 years.
What kind of hours do you work?
I work about 40 hours a week.
But is it morning, night?
Oh, mornings.
And is that like 7 a.m. or
7 to 3:30.
Pardon me?
7 to 3:30.
Got it. Okay. Monday through Friday?
Yeah, well, it's flexible. It's sometimes Monday through Friday, or I'll work weekends. It just depends. It's everywhere.
Got it. All right. Do you have any questions about anything we discussed?
No.
Mr. Gordon, you know who I'm talking about?
Yes.
Is he the father of your son?
Yes.
Did you know he was, Ms. Dilligard, the father of a shared child?
I did not. So I would just ask the court to do a no violent contact order.
Okay. Ms. Albert, how would you describe your relationship with Mr. Gordon at this time?
We don't speak, but I speak with his grandma. Like, if he wants to get his son, she'll like pick him up and then take him through her.
So you've gone separate ways, but you have this, what's your son's name?
Israel Gordon.
Israel?
Yes.
All right. So you have a connection with Mr. Gordon through Israel, but his grandmother, Mr. Gordon's grandmother, is the one who gets Israel. So you don't have to have contact with Mr. Gordon?
Right.
Okay. Is that a viable way for us to move forward, that we actually have a no contact provision, but if he wants to see his son, Mr. Gordon, he'd just sort of do that through grandmother?
Yeah, that's fine.
Okay. And you don't have any reason to contact Mr. Gordon?
No.
Is he providing support for Israel?
Yes.
How does he send you money or drop off pant? He doesn't know if your kid needs diapers anymore. How is he getting you support?
Well, I just really just speak with his grandma. Like, it's really she comes and picks him up and then she brings him back. Like, he buys his stuff, I buy my stuff.
Okay. All right. I'm asking these questions not because I'm nosy. If you have a condition of no contact with Mr. Gordon, then that means no contact. And if you guys have to connect once a week because he's bringing you some money or he's bringing back Israel or something, then you're having contact. And I don't want you to be violating the terms of your sentence.
Yeah, it's no contact at all. We don't speak at all.
Okay. Well, we'll keep it that way. That's probably better for everyone.
Yeah.
All right. Well, Ms. Albert, I find there is a factual basis for your plea and that your plea was knowing and voluntary, meaning you've understood what we talked about and no one has forced you to enter your plea. Do you agree with that?
Yes.
I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a minor or technical violation, you don't have to come see me. Probation and you can work that out. But if it's more serious, you get arrested for anything, or you have contact with Mr. Gordon, those kinds of things come back to me and we'll deal with the consequences. Mr. Rosenblum, can someone in my office sign the indictment on your behalf?
Absolutely, Your Honor.
Ms. Dilligard?
Yes, Judge.
And Ms. Albert, is it okay if we sign the indictment indicating your plea?
Yes.
We'll do that. I am going to follow the negotiated plan, sentence you to 5 years probation. Special condition number 1 is that you complete the Family Violence Intervention Program. That's not just one class, it's actually a series of classes. You'll need to do all of them, and it'll be part of your probation that you enroll in that within the first 3 months you're on probation, okay?
Okay.
Number 2, you need to complete 50 hours of community service, and you need to have completed at least 20 of those in the first 6 months of probation. Special condition number 3 is that you have no contact with Mr. Gordon. Don't write him, don't text him, anything like that. Now, what is his grandmother's name?
Marlo Howard.
Marlo Howard. that is okay contact. If you end up getting a message to Mr. Gordon through Ms. Howard, because you have a shared child, that's okay. But otherwise, don't call him, don't write him. And if you have some shared friends, don't send word through them. It's just you go through Ms. Howard, okay?
Yes, sir.
And finally, you're going to need to have a mental health evaluation. You'll sit down with a doctor or a therapist. And if that person recommends any treatment, whether it's, hey, you should go to AA classes or go see a doctor or whatnot, that treatment will be part of your sentence. I am going to sentence you as a first offender. You qualify for that. You have essentially zero criminal history. That's primarily a benefit. It means that when we're done here today, you are not a convicted felon. You will be under sentence, but you don't have a felony conviction. And if you successfully complete your sentence, you will continue to have no felony criminal history, and you can get this expunged from your record, which will help if you really want to go back to Georgia State or go to Georgia State or anything like that. Not having this as a felony conviction is a very good thing for you as you chart your course into the future. I will set a behavioral incentive date, which means if everything is good with probation, you've done all the things you needed to do, haven't otherwise gotten in trouble, probation may end your sentence a little early. And I'll set that for July 9th of 2028. That's 3 years from now. If you've done well, no need to keep looking over your shoulder, meaning probation looking over your shoulder. Last thing I need to share with you is that there's a risk to first offender. I want to make sure you understand that. If you end up not being able to stay out of harm's way and get arrested again for something, especially if it's something where you and a significant other get violent with each other, not only would you have new charges, but you'd come back in front of me and I might well say, gosh, Miss Albert, we misread you. You were going to go back to school. You had a good job, but you're a brawler. You're always doing something to someone and they're getting hurt. I could resentence you as an actual felon because you've pled guilty. You said I did this thing, and we're starting out as first offender, but I could revoke that first offender status and sentence you up to the maximum in this case, which is up to 20 years. I'm not saying that's what I do, but I want to make sure you understand the exposure you have here. If you stick scissors in the side of a boyfriend a year from now, I will revoke a whole bunch of years and you'll have a felony as a result of this plea. Do you understand that?
Yes, sir.
Okay. Do you feel like first offender makes sense for you?
Yes.
You think you'll stay out of harm's way between now and July 9th, 2028?
For sure.
For sure, she says. Okay, then I'll sentence you as a first offender. I think I've covered everything, except, do you live in Fulton County?
Yes.
All right, you're going to get some probation reporting instructions in just a moment from Ms. Simpson, who's with probation. Ms. Dilligard, anything else in Ms. Albert's case?
Nothing further, Judge.
Mr. Rosenblum?
Nothing further, Your Honor.
All right, Ms. Simpson's coming up to the microphone here, and she may have a few questions for you, but mostly she's going to be giving you some reporting instructions. So if you want to write it down, either you or your lawyer should write this down, okay?
Okay.
All yours, Ms. Simpson.
Thank you, Judge. Good afternoon, Ms. Albert.
Hi.
I need your residential address, please, for the record.
3440 Boulder Park Drive, Southwest. Apartment 302, Atlanta, Georgia, 30331.
All right, so your reporting date will be July the 11th. That is on a Friday at 9:30 a.m. And you're going to report to the Atlanta Probation Office, and that is 276 Memorial Drive. And that is in Atlanta, Georgia, and the zip code is 30303. And I'm going to give you the contact number for that office. That is 404-463-0410. So if you have any questions or any issues being able to report, please contact that office immediately.
Okay,
Thank you.
thank you.
Thank you, Mr. Rosenblum. Good
You're
luck,
welcome.
Ms. Albert.
Thank you, sir.
All right, bye-bye.
Have a great day.
You too.
Is Miss Clark still back there? She just busted out of here. Okay. In what order would you all like to go on the defense side?
Zachariah Williams, is it thing?
Let's do it. She who speaks first.
Oh, yeah, I'm sorry.
That's
Yeah.
okay.
Yeah, oh, for me too. Yeah, it is. My bad. Jasmine and Rosalina, so we can do Miss Tillman.
Okay.
Sorry, I forgot.
It's all about Dilligard.
Very upset.
You get into some unit and it's like, oh, wait, is she feeling okay? What would work for her? All right, Ms. Tillman, can you turn your camera back on, please?
Yeah.
She comes. All right, I think that works with those cameras. All right, Ms. Dilligard, are you ready?
I am.
We'll go on the record. This is 25 SC 000753, State versus Tillman. Ms. Tillman is appearing virtually. Her lawyer, Ms. Wood, is here in court. We have Ms. Dilligard for the state. Ms. Tillman, I need you to unmute now.
Okay.
Thank you. You are appearing from where? Are you at home?
Yes.
Okay, that's fine. Do you waive your right to be here in open court and agree to?
No.
It's okay. You're going to actually be unmuted for a while because we're going to be asking you some questions. One of them will be, hey, do you have any kids? It sounds like in your household you do. But
Yes.
do you waive your right to be here in court and consent to appear virtually?
Yes.
Do you waive your right to have Ms. Wood by your side and consent to having her in court while you are wherever you are?
Yes.
Okay. In a moment, Ms. Dilligard's going to put you under oath and ask you a bunch of questions. If you listened into the last plea, they're going to be very similar questions. I need you to answer those questions truthfully, but also to let me know if you have questions of your own. Will you do that?
Yes.
Okay. Ms. Dilligard?
Tillman, can you please raise your right hand? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your true and correct legal name for the record?
Tanea Nicole Tillman.
Ms. Tillman, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Oh, I'm sorry. You can put your hand down.
Okay.
How old are you and how far have you gone in school?
I'm 22 and I finished high school. I'm going into college this fall semester.
Where will you be going to college?
Edmonds Community College.
What was the first word?
Edmonds.
Where's that?
It's in Edmonds, Washington.
Is that where you are right now?
Yes.
The state of Washington?
Yes. I had to leave for my safety.
Okay, well, I'm sure we'll hear more about that while we have this conversation. Is Edmonds near Seattle or?
Actually, no, it's near Everett, which is, you probably won't know where that is either.
Nope.
But Seattle is
Okay.
not close.
Okay, but all of Washington is far from Georgia. So if you needed to be far from Georgia, you get an A+.
Thank you.
Okay, Edmonds College it is.
Okay. Ms. Tillman, Do you understand that you've been charged with the following offenses? 1 count of aggravated assault and 1 count of battery.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment to include the facts and circumstances related to the charges?
Yes.
Do you need any more time to discuss the case with your lawyer?
No. I like the boy.
Are you satisfied with your lawyer's services?
Yes.
Okay. Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
So wait.
Ms. Tillman, do you remember being arrested on these charges?
Yes.
And has your attorney advised you of the minimum maximum sentence for the charges to which you're pleading guilty to today? So we, judge, are reducing the aggravated assault to reckless conduct. Both the reckless conduct and the battery charge carry a 1-day to 12-month sentence. You understand?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? To plead to the reckless conduct and the battery for a sentence of 24 months of probation. For the defendant to complete a mental health evaluation and any recommended treatment. To complete the family violence intervention program and 40 hours of community service. And to have no violent contact with the victim.
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum sentence on each charge?
Yes.
And do you understand if the court decides to order a sentence that differs from the plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're placed on probation, you must follow the special conditions of your probation?
Yes.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses to include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a plea today?
Yes. Okay, Lily.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes.
Ms. Tillman, how do you plead to the reduced charge of reckless conduct and battery in indictment number 25 SC 000753?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the facts are a little hard to follow, but
I just read there's something with pepper spray. That's all I know.
Yes. So on December 12th, 2023, Fairburn police officers responded to a reported dispute at 8801 Seneca Road. Upon arrival, officers spoke with Miss Tillman, who reported that the victim had kicked her in the chest and dragged her out of the car. Officers then made contact with the victim, which is Eric Rankins, Rankins. They immediately noticed redness to his right eye, a swollen face, and a lacerated bottom left side lip. The victim stated that the defendant sprayed him with pepper spray. He explained that he had just been completing a food delivery order when he tracked his cell phone to that location. The defendant was utilizing his extra phone of his, and so he tracked that phone to that location. He attempted to retrieve the phone from Miss Tillman, who was in the vehicle with another male at the time. The defendant then punched him, sprayed him with the pepper spray. The victim was then able to get away, parked his car nearby. He couldn't drive because of the pepper spray in his eyes. That's the factual basis for the case.
Were Mr. Rankins and Ms. Tillman at some point an item, or was it a stolen phone?
No, they were an item, is my understanding. And
then she had a second item, maybe this guy in the other car. Mr. Rankins may have viewed it that way and was coming to figure out where is she,
Right.
and I'm getting my phone back.
Yes, so
Okay.
he thought it was weird that it was that late at that location, but there may have been some Uber delivering going on.
I'm sure we'll hear more, like, you know, always the other side to the story. But he got sprayed and smacked in the face.
Yes.
Okay.
Yes. And so the office has had contact with him. I was just looking at my notes because they just made contact with him about an hour ago again. He said that they no longer live together. They haven't had any issues prior to this incident. He did request for the charges to, she didn't need any jail time, just needed possibly a mental health evaluation is what he indicated. When I reviewed her criminal history, I only saw 3 arrest cycles. I did see a criminal damage with the same victim out of Rockdale County that was reduced down to a criminal trespass, and I believe the defendant did PTI for that.
Okay.
Nothing further from the state.
Got it. Thank you. Mr. Howard, can you share the criminal history information you have on Ms. Tillman?
Third cycle, 2024 failure to appear out of Rockdale, and the 2023 trespass, no felony conviction.
All right. Thank you. Ms. Wood.
Yes, Judge. So Ms. Tillman is 22 years old. She's a high school graduate. She is going to be attending Edmonds Community College in the fall, as you heard. And as you know, she no longer lives in Georgia. So I would ask that if we put on the final disposition to just make sure that it's okay that she does call in reporting misdemeanor probation. I have had out-of-state clients have issues with that in the past. And I will let her share, Judge, if she wants to elaborate. I do just want to note, this is a 2023 incident. They are no longer together. She did leave the state for her safety. There were issues before this where she was actually on the receiving end of some aggression and
From the guy in the car or from Mr. Rankins?
Rankins.
Okay.
And also, I would just note that he traveled from Conyers to Fairburn this night.
To go get his phone.
Yes.
Okay.
Otherwise, I would just ask that the court consider waiving the probation fees so that she can pay for the family violence classes. And then also my last request, if the court would consider suspending the probation after she completes the special conditions.
Okay. Got it. Ms. Tillman, do you have any questions?
No. I have a statement, but no questions.
Okay. Well, that was my next thing. Is there anything you want to add to what I've heard?
Yes.
Okay.
Not only did he travel from Conyers to Fairburn, but he dragged me out of my car. Like, he's crazy. He's crazy.
Okay. So he was losing it.
Yeah.
All right.
Yeah.
I hear a little kid in the background. Is that your child or are you
That is
babysitting?
my child.
Okay. How old is your child?
He's 5.
What's his name?
Genoa, Johnoah, Tillman.
Genoa, I like that.
Yes.
Is Mr. Rankins his father?
No,
Okay. So there's no reason for you and Mr. Rankins to have any contact?
no, thank God.
Okay. Well, we'll make it no contact at all then between you and Mr. Rankins.
Yeah, no.
Is Genoa's father present in his life at all?
Yes.
Okay. Is he in Edmonds, Washington?
No, he's actually down there in Fairburn.
Okay, got it. All right, well, I don't think I have any other questions for you. I do find that there's a factual basis for your plea and that it's knowing and voluntary. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes.
Ms. Dilligard?
Yes, Judge.
And Ms. Tillman, is it okay if we sign for you as well, indicating your 2 misdemeanor pleas?
Yes, sir. Cool beans.
Cool beans it is. All right. So what I'm going to do, Ms. Tillman, is sentence you on count 1, which has been reduced to reckless conduct, to 9 months probation, and count 2 battery to 9 months probation. Bless you. Those will run consecutive to each other, so it's a total of 18 months probation. Special condition number 1 is that you have no contact with Mr. Rankins. That should be easy. It should be what you want. Hopefully it's what he wants. Do you think he even has an idea where you are? I don't know how you guys left things.
He tries to call my dad. I completely left him in the past. Relationships
good.
like that don't need to be anywhere. Doesn't make progress happen. So, no, I'm
Okay,
moving forward with my
good.
life.
Good. Let's keep it that way. So no contact with Mr. Rankins. You'll need to complete a family violence intervention program, which is a series of classes about managing relationships. You'll need to complete 40 hours of community service. And you'll also need to meet with some medical professional to have a mental health evaluation. And if that medical professional recommends any treatment, that treatment becomes part of your probation. I will let misdemeanor probation know that call-in reporting is acceptable for you, so you don't have to travel here to meet with probation. And I will waive your probation supervision fees for the first 4 months. Are you planning on working as well as, are you going to be a full-time student or are you going to work and be a student?
I'm actually self-employed. I do nails.
Okay, so will you continue to do nails while you're a student?
Yes.
All right, well, good. How do you get customers in Washington? How do they know about you if you've been here for a long time?
I had to change all of my social media, so that option is gone. I just hand out my cards and, self-promoting through real people.
Got it. Okay, well, good luck with that. Anything else, Ms. Dilligard?
Nothing further, Judge.
All right, anything else, Ms. Wood?
No, Judge, thank you.
How do you think Ms. Tillman's going to learn about the probation reporting process?
I will submit all of her information and then they'll reach out.
Great. So Ms. Tillman, you're going to get a call or an email from misdemeanor probation. Make sure that you connect with them, because if you don't, then they send me a warrant saying we can't track this lady down. You want to be easy to find, but Ms. Wood is going to give misdemeanor probation your contact information, so they shouldn't have any trouble getting in touch with you. All right?
Not at all.
Okay. Anything else?
Not for me.
Okay, that's what I was asking. All right. Well, good luck with things. I hope school goes well and that you start getting customers there in Washington.
Thank you.
All right, take care.
Thank you too. Oh, can I leave now?
You can. You're free to go.
Okay, thank you.
Uh-huh.
Bye. Oh,
Cool beans.
cool beans.
Oh, no, you don't. Don't worry.
Judge, that concludes my business today. May I be excused?
Yes, ma'am. See you around.
I did see Ms. Willingham today, so.
Yeah, I saw that this little email went out of the new hires in the county and it listed, you guys have a bunch of people coming in.
Yeah.
About time. But she was the only retread that I noticed in there. And I saw her name connected to, oh, if we end up trying, it won't be we, if Judge Emerson tries the right case, it listed her name.
Oh, good to know.
Diving straight into it. Okay. Well, thanks for bringing her back. What's next? Whoever's sneezing, let's do the one where we get the sneezer out of here. All right, come on up, Mr. Lawson.
Yeah, that's the only way to see sometimes. And I guess I'll go up to my little cubby hole.
Y'all
not, it's not just cold.
Yep, no, it's smart. Oh my God. Mr. Lawson, can you move that monitor up a little bit so it gets your head? You can, it's okay, no, just grab the whole monitor and angle it up a little bit. A little more. Good, thank you, perfect, appreciate it. Let me know, Ms. Davis, when you are situated.
Thank you, Judge. I am ready.
All right, this is 23 SC 188455, State versus Ronald Lawson. Mr. Lawson is here in court with Ms. Rios. Ms. Davis is representing the state. And Mr. Lawson, it sounds like you're ready to enter a plea in your case, is that right?
Yes, sir.
Okay. Ms. Davis will put you under oath and then ask you some questions. You need to answer those truthfully and let me know if you have any questions of your own, okay?
Yes, sir.
All right, when you're ready.
Please raise your right hand. Do you swear or affirm the testimony you shall give in this matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Ronald Lawson Jr.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
49, 10th grade,
And what school did you attend?
Washington, Booker T. Washington High.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you are charged with the following offenses in Indictment 23 SC 188455, one count of possession of a firearm by a convicted felon, reckless conduct, and expired or no license on person?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Rios, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Lawson, do you remember having been arrested on these charges?
Yes, ma'am.
Judge, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to this case?
No.
Mr. Lawson, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading today?
Yes, ma'am.
Possession of a firearm is a 5-year consecutive sentence, and reckless conduct and expired license are misdemeanor offenses, which is the maximum of 12 months.
So possession of a firearm by convicted felon is, it's either 1 to 5 or 1 to 10.
Oh, I'm sorry, 1 to 5.
I know it's sort of shift, it's first, so just 1 to 5, okay.
Do you understand that do you understand that you're entering a blind plea, also known as a non-negotiated plea? The state will still recommend a sentence to the court.
Yes, ma'am.
Do you understand that a court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction at trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Understand.
the right to the presumption of innocence,
Understand.
the right to testify on your own behalf and present other evidence,
Understand.
the right to subpoena witnesses and compel the production of evidence,
Understand.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you may have only 4 years from today for the felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 23 SC 188455 for possession of a firearm by a convicted felon, reckless conduct, and expired or no license on person?
Good.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Judge, we believe the facts would bear out at trial that on May the 10th, 2023, at about 1:44 in the morning at 608 14th Street in Atlanta, Georgia, in Fulton County, that the defendant, Mr. Lawson, was operating a vehicle, a silver Lincoln sedan. He drove to the gas station and there was a liquid leaking underneath the vehicle, which drew the attention of some construction workers. And basically they reported to an officer that Mr. Lawson had struck one of the poles in the area. And then when the officers encountered Mr. Lawson, they were able to observe a firearm, I believe, in his waistband. And Mr. Lawson is a convicted felon who is prohibited from carrying firearms. He also was operating a vehicle without a valid license. Mr. Lawson was convicted on September 13th, 2011 in Fulton County for the purchase, possession, or distribution of marijuana.
The indictment charges him with discharging the gun. I didn't hear you talk about that. Count 2, the reckless conduct, is endangering people by consciously disregarding the risk that shooting his gun while driving his car would endanger people. So not that he shot at someone, but I don't know if he was shooting in the air or target practice or what.
They identified his Smith & Wesson firearm as distributed. I guess it had 7 live rounds, and they removed from his pocket. They also noticed that there was a rear window that was shattered, where they believed it was a exit point of him shooting the weapon.
So Okay.
They basically are saying that he shot the weapon from his vehicle. And he struck a fixed object while shooting his weapon.
Okay. All right.
So he basically shot the weapon and ran into a light pole. On 14th Street.
Okay.
10th Street, actually. It does indicate that Mr. Lawson said that someone was shooting at him and he returned fire.
Okay. Okay, got it. Mr. Howard, I have it's not a recidivist notice, but the repeat offender notice. So I know that there are 5 prior felonies. I'm interested in what you've got, if anything, since this arrest. So May 10th of 23 was when this case happened. Do you have any criminal history information after that?
Let me look, because I had already did my notes, and I got the 5 felony convictions too. Hold on. What's his last name? Lawson.
Lawson, Ronald Lawson.
No, because the last arrest I got is May 10th, 2023.
Okay.
Okay.
Got it. Thank you. Ms. Rios?
Yes, Your Honor. Mr.
Oh, wait, I'm sorry. What's the recommendation?
My recommendation was 5 years to serve 1 year, balance on probation, get a GED or obtain employment, and for him to enter a treatment program, which I believe he's been accepted.
He hasn't.
Sorry, wrong person.
Yeah,
Treatment
that's
program. Okay. Well, it
Phil
was,
Johnson.
I'm sorry. It was 5 years serve 1 GED or employment and 40 hours community service.
Okay, got it. Ms. Rios?
Yes, Your Honor. Mr. Lawson's 49 years old. He has 3 children, ages 6, 9, and 12. He had a 31-year-old son who passed away. He's currently working for People Ready. I sent you a copy of his work schedule. I know it was kind of hard to see because it was in a picture, and that's what he sent me, but he currently is working there, and I think another temp service too, doing construction and warehouse work. He also volunteers at Lovely Organizing Services. I did send a letter showing that he does volunteer there. His fiance is here in support of him. I'm asking that he be sentenced to 5, serve 42 days. He did 42 days in custody. This incident occurred like 2 years ago, I believe, at this point, and he hasn't had anything since. Don't believe he's not on probation or parole or anything. So we just ask that you sentence him to the 42 days so he can allowed to continue to work and care for his young children.
Mr. Lawson, I'm sorry you lost your eldest son. You've got 3 much younger kids. Do they live with you?
No, sir, over their mother.
Do they all have the same mom?
Yes, sir.
Okay. And tell me what you do for people.
Construction.
Construction?
Yes, sir, construction.
Okay. And is that a temp agency where they may send you out to a project here, then a project there?
Yes, sir. I've been on them for over 10 years.
Okay.
Yes, sir.
So that's pretty reliable for you?
Yes, sir. Very reliable.
It
It pays the bills.
It pays the bills. You've got a fiance. Does she work?
Oh, not currently.
Not currently.
Yes, sir.
Okay. Tell me about this situation. What do you remember about it?
I had just got my income tax, and through the whole day, I had just bought the car, and through the whole day, someone had been following me from the bank the whole day. So when I left and peeped my part, they were still following me. So they took a shot at me, and I was just trying to defend myself, just get them off me. I took a shot back. I was just trying to get a getaway. And I told the cops to run they ran their cameras back and everything. They knew what I was saying was true. That's why they never tried to charge me with the shooting, because they seen everything that I told them was true. People had been following me the whole day.
Okay.
Got my income tax the same day. You know what I'm saying? They were trying to follow. So I guess they were trying to rob me. I don't know what the situation was, but I was just trying to get them off me.
Okay. You weren't supposed to have a gun.
No, sir. But to my understanding, sir, I know I wasn't supposed to have a gun, but they say if you haven't been in trouble over 10 years, they were saying that you can I could have went and did something about the firearm. I could have went and did something and obtained the firearm the right way, but I didn't go by the right way though.
Yeah, so I don't know about that advice. Unless you get your criminal history expunged and your rights restored, it could be 100 years and you can't get a gun. So when you go home, you may want to get guns out of your house if you got guns in your house. And you don't need to tell me. I'm just letting you know, it's not 10 years or 11 or 20 or 40 unless you get your rights restored. And you'd know that because you'd be carrying around a certificate that said, nope, look, it's okay, officer. I can have this firearm I just used to shoot at this guy who's been following me all day. You do, it sounds like good hard work, construction. What days of the week do you work?
Monday through Friday.
Monday through Friday. Sounds very regular. What are the hours?
6. No, we go in at 6 before dawn. Be off like 3:30, 4 o'clock.
Okay. Got it. Any questions about anything we've discussed or anything you heard from Ms. Davis?
No, sir.
Okay. Well, Mr. Lawson, I find there's a factual basis for your plea. This was a while ago. Sounds like a creepy situation for you if someone really was following you. Maybe next time you get the cops to intervene rather than you play sheriff. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to enter this plea. I'm sentencing you pursuant to the Probation Options Management Act because you'll be on probation for a little bit. While you're on probation, I hope you have no violation, but if you have a small violation, you and probation sort that out.
Yes, sir.
But if it's a bigger issue, you get arrested for something, that comes back to me. Ms. Rios, can someone in my office sign I think it's an accusation in this case. Can we sign for you?
Yes, sir.
Okay. Ms. Davis?
Yes, Judge.
And Mr. Lawson, can we sign it for you?
Yes, sir.
We'll do that. Do you have it's going to seem like a strange question given what we just talked about, but I need to ask it. Do you have a weapons carry license?
Yes, sir.
Okay, good. You shouldn't. But if you did, I have to forfeit it. So Mr. Lawson, you've been around the block a few times. I'm looking at your repeat offender notice. But it was a while ago. You had a cocaine thing 8 years ago, but a lot of your stuff, your lawyer might not even have been a student in any school at the time you picked up some of your VGCSA cases. So you seem to have gotten a little better with some stuff, but this was a bad situation to be in. I am going to sentence you on count 1 to 5 years to serve 1 month. Counts 2 and 3 will both be 1 month to serve. These will all run concurrently with each other. You'll get credit for the time you have served. But before you celebrate, special condition number 1 of your probation is that you are going to complete 15 weekends in jail. So you're going to turn yourself in by 5 p.m. the county jail every Friday. It's not going to interfere with work. And you'll get out Sunday, 5 p.m.
Okay.
And that's going to start, since we're only on Tuesday, any reason we can't start this weekend, or you want to start the weekend after?
We can start this weekend.
This weekend? So that starts, so the 11th, this Friday, you go to Rice Street. They're going to know you're coming. You probably won't get way up in there. You may stay in intake for the whole weekend. But more importantly, they let you out Sunday at 5.
Okay.
Okay? And there's going to be 15 consecutive weekends of that. Each one is a reminder, no gun, don't drive without a license.
Yes, sir.
No gun, don't drive without a license. If for some reason there is a family emergency, your fiance is sneezing too much, or one of your kids is sick and you cannot make it, you got to call probation and say, hey, it's Friday, I'm going to the ER with my girlfriend. And you want to get documentation that that's where you were in the ER. Because you miss one of these weekends, probation lets me know. And that's the kind of thing that comes back to me. And I will convert those weekends into months or something like that. And you don't need that kind of time out. You're working hard. It sounds like you're taking care of business. Special condition number 2 is that you will submit to a drug and alcohol abuse evaluation. That just means you're going to meet with someone who's going to say, tell me about what's going on in your life. And if that person recommends any treatment, then you'll get that treatment, whether it's going to AA classes or NA or whatever. And that person may say, hey, everything's good with Mr. Lawson, but they're going to check and see if you would benefit from any treatment. You'll need to complete 40 hours of community service. And you'll need to do, well, your weekends are going to be full for a little while. So I'm not going to set a start date for that, but make sure you take care of the community service. If you are not working at least 20 hours a week, then you need to enroll in a GED course to get your GED. If you're working full-time, keep doing that and don't worry about the GED. I think that's all I got. Ms. Davis, anything else in Mr. Lawson's case?
Yes, Judge, just for the record, I did file a recidivist notice. We would be waiving that
Oh.
requirement.
Look at that. You did. Okay. It's good to see those in the docket. So the state's withdrawing the recidivist notice. Ms. Rios, anything else on behalf of Mr. Lawson?
No, Your Honor, thank you.
Mr. Lawson, do you live in Fulton County? All right. Ms. Simpson, who's seated in the jury box, is with probation. She's going to give you some reporting instructions. So stay right there. Listen to what she has to say, and then you will be all set. Any questions about anything?
No, sir. No, thank you.
Okay.
What is the zip code?
30318. 18.
So your reporting date will be July the 15th, mortgage for trust. We need to report to 276 Memorial Drive at 8 p.m. It's the 15th. Do not leave.
You're following instructions. That's good. Don't leave.
Any question?
Mine's with Jesse. Can you come out?
Nope.
Oh, okay, well.
Sure.
They tell me that I have to go to jail. They just call it. I know it's not the right thing. That's good that you can jail. Awesome.
Yes.
So Ms. Rios, who are we doing now? Okay. And we have actually no deputies right now. This should be where everyone wants to be. I don't understand that. Apparently not.
Well, they don't need like 4 people at the front. It's like a lot of people at the front. I'll be glad to work.
You need him at the front. He tries to come in and do something crazy.
How you doing, Mr. Davis? Not so good. I don't like hearing that.
Well, that's the truth, though.
Okay, well,
Illegal, on their way.
pardon me?
Brighter days are on their way.
I hope so. Ms. Niles is taking a look at your paperwork.
It's just a notice of appeal. I don't know why they even,
I don't know, the clerk's office does their thing.
because every other time I go there on an engine on application, I never have that problem. They just look at it, if they don't grant it, they grant it, if not, I'll.
Right.
pay for it.
Okay. Well, hopefully we'll get you out of here quickly. We're trying to do Mr. Johnson, but we need 2 deputies. Well, have him be more than right there.
Judge, I saw the daughter, from that really big substance there this morning.
What happened?
Saw the guy from that real estate civil case, here this morning.
Oh, where like there are liens on his, yeah, but you don't have a case. That's the problem, is they won't file anything. He just walks in, he's like, hey, would you help with this? And Ms. Niles has said, you need a case number because it sounds like they're bogus liens on the property, but you need to file something to remove it. It's not just like a drop in. We're ready for Philip Johnson when you guys are ready. But yes, he was here.
Thanks. So we're always on the Instagram. I keep getting videos sent to me that's on Instagram.
We don't feed through that, but people may put it there.
Like for videotaping it or sending it to me.
Oh, wow.
Yeah.
All right, Ms. Rivers, you ready? This is position 1 on our calendar, State versus Philip Johnson, 24 SC 004-947. Good afternoon, Mr. Johnson.
Good morning. Or good
Afternoon.
Sorry.
That's all right. I know you've been stuck back there for a while.
Yes, sir.
Ms. Rios tells me you're ready to enter a plea.
Yes, sir. Guilty, Your Honor.
Okay, well, we're going to work through it question by question. Ms. Davis is going to put you under oath in just a moment.
Okay.
Listen carefully to her questions and let me know if you ever have a question. Okay?
Yes, sir.
All right.
All right, Mr. Johnson, please raise your right hand. Do you swear or affirm the testimony you shall give before this court today shall be the truth, the whole truth, and nothing but the truth?
Yes, sir. All right, yes,
You
ma'am.
can
My
put-
bad.
Okay. Circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of the indictment and any and all defects in therein for the purposes of this plea?
Yes.
Mr. Johnson, do you remember having been arrested on these charges?
Yeah.
Judge, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Johnson, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading today?
Yes, ma'am.
For terroristic threats, it's 1 to 5 years, and for public drunk, it's 12 months.
Yeah.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, I'm just ready to get the program.
Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has a right to sentence you to the maximum possible sentence on each charge?
That's fine.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has a right to run those sentences consecutively or one after the other?
That's fine.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including in federal courts?
That's fine.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at trial would? And that is true regardless of any advice given to you by your attorney or anyone else.
That's fine.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence from 1 to 15 years in prison?
That's fine.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, or to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of the case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charge and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 004947 to terroristic threats and public drunk?
Plead guilty.
Has anyone forced you, threatened you, or promised you anything to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is there a guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yeah.
All right. Judge, we believe that if this case were to go to trial, that the record would show that on July 17th, 2024, at about 8 o'clock in the morning, an officer responded to 9700 Medlock Bridge Road in reference to a disorderly person. Hold on, sorry. My computer is loading up, Judge, but I just need one moment, sorry. So I don't believe that the correct address. Okay, I'm sorry, Judge, but it was on July 17, 2024, that an officer encountered the defendant at State Bridge Road in Johns Creek, Georgia, in Fulton County. And that the officer encountered him because he was initially crossed a roadwalk, but not in the roadwalk, advised him to do so. He didn't. He attempted to issue a ticket to the defendant, and he became kind of boisterous. They took him to custody, and then at that time, the defendant made threats to kill the officer. They also smelled the distinct smell of alcohol on his presence. So that's why he was charged with terroristic threats and public drunk.
When you say a road walk, is that the same as a crosswalk?
Yes, Judge, I'm sorry,
Okay.
crosswalk.
No, I thought maybe that was just another local term for it. So he basically jaywalked, that got the attention of the officer. It went downhill from there.
Yes, and yes, from the video, the officer just asked him to use the crosswalk, and when he didn't, that's when they got engaged.
Okay. Understood. And it looks like Mr. Johnson's been in custody for a while. Was it an FTA, bench warrant, not a probation issue?
It was a bench warrant, but we didn't want it until we found housing. Oh, no.
It's all good. No, but there's not a probation issue we're working through.
No,
It was
I
just
don't
a
believe
missed
so.
court date and you've been looking for a program for it.
Yes, sir.
Okay, thank you. Mr. Howard, how many cycles do you have for Mr. Johnson and how many felony convictions?
Got 30. On probation out of Gwinnett, first offender. Yes, for ag assault. I don't see any other felony convictions, but he did have a 2024 misdemeanor terrorist threat conviction.
Okay. And you said 30-something cycles?
30.
30. Okay, thank you. Ms. Simpson, do you have Mr. Johnson in the system as being on probation?
That expires in October of this year.
Okay, almost done. All right, Ms. Rios.
Yes, Your Honor. Mr. Johnson is 41 years old. Majority of his life, he's been working with scrap metals and to make engines for cars and trucks. He doesn't have any children and he went up to the 10th grade. We did get him into a Better Way ministry, so he'll be getting services for his longstanding alcohol abuse issues. And I've already provided the acceptance letter and the transport order to the court. I was hoping that you accept the plea as negotiated.
Okay. Sonoya, is that something the sheriff will get someone to? Sonoya's not super close. Okay.
That's the.
Just thinking about the transport order. We'll find out.
Okay.
Have you had clients go to a Better Way?
I thought so.
Okay.
So
I know we've used it before. I just was thinking through, because I was going to ask Mr. Johnson, you know where Sonoya is?
No, sir.
Okay, it's not in Gwinnett County.
Okay. Well,
Yeah, it's a little further away, which is good. I just want you to know if you have friends or family in Gwinnett, you're going to be a little further away than that because you're going to be focused on recovery.
I'm just going to get the program right, get it done, get it over with.
Okay, got it. Do you have any questions about anything we said?
No.
Okay. Well, Mr. Johnson, I find there's a factual basis for your plea. And it was about 2 years ago, no, just last year, just about a year ago, a little less than a year ago, you were up in Johns Creek and you were not in good shape. And you got into it with the officer. So I find there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. You agree with that?
Yes, sir.
And knowing means you've understood the things we talked about. You agree with that? All right. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a minor infraction, you and probation will deal with that. But if you get arrested for something, if you get kicked out of Better Way Ministries, or you just quit, that comes back to me as a violation.
Yes.
Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Johnson, is it okay if we electronically sign the indictment on your behalf?
Yes, sir.
Okay, then we'll do that. I'm going to sentence you on count 1 to, want to make sure you don't pop out too soon, but I think we'll be all right. 4 years to serve 7 months with the balance probated, and count 2 will be 7 months to serve. They'll run concurrently with each other. And you've done 200 days, so you are just a few days away from the 7 months, but that'll keep you in place until the transport can go.
Okay.
And I'll make sure if I need to make it 8 months, that's only just to keep you in place till the transport can occur. And then that balance will be probation. So it's a little bit more than 3 years probation, but not much. Special condition of probation number 1 is that you complete the Better Way Ministries program.
Yes.
It's by 18 months if everything goes well. And I'd like you to get all the way through that. If you quit early, that's a violation of your probation.
Your Honor, as long as they give me an apartment and a job, I'll be all right.
They're going to do all that. So I hope you stick with it. Do you have friends or family in Johns Creek?
No, actually, my boss lives there, but I'm jumping back from Gwinnett County, Polk County because of work.
Okay,
That's the only reason I need to show up probation because of work.
okay.
But
Well, I'm gonna say,
now if I'm not working, I'm ready to do the program and get that done and get out of the way, sir.
okay. Well, I'm gonna have you, while you're on probation, stay out of Johns Creek, okay?
That's
So real simple, just no Johns Creek for you.
That's fine.
All right. Anything else, Ms. Davis? I know you had asked for community service, but the Better Way program is long enough that I'm gonna rely on that instead.
And I believe you mentioned staying away from Johnson Creek.
Johns Creek, don't go to Johns Creek, whole city.
Thank you, Judge.
You bet. Ms. Rios, anything else?
No, Your Honor, thank you.
So, how is it gonna work with probation? If Mr. Johnson sticks with the program for 18 months, he's gonna be living in Sonoya. Do we still have him report?
That residential.
Yeah.
It is.
So I'm gonna need that address and a contact number.
I have a copy of,
Because what they're gonna do is they're gonna announce when they're gonna transfer his case for that.
So I bet you can give him there's a phone number on the letter of acceptance. There's not, an address. It just says it's in Sonoya. Oh, no, it has an address too. Yeah, so if you have a copy, do you need me to print one out or you've got one?
I think I have one.
Let me see if I can get this page to print. It's working. The transport order is something you've sent Ms. Nelson?
Yes.
Okay. Here you go. Thanks. All right, Mr. John, do you need it to tell Mr. Johnson anything else or?
Normally it would be for 48 hours, but given that,
I don't know exactly when he's getting out because we've got to do the transport order and,
right, but I mean, even still, he's gonna be up there, over there. So, what I can do is contact his officer to see if they can, either one, go ahead and transfer his case, or do one initial visit and then transfer his case out just so that they can put eyes on them. Since he's new sentence.
okay, got it. So you know your probation officer in Gwinnett?
No, I don't. I don't have any information out of that.
Had you ever met someone from probation before?
I saw a white attorney, but it's weird.
Okay.
I need y'all to call Gwinnett for me too and let them know where I'm going.
All right, I think they'll sort through that.
He's not on supervised.
Oh, so he wouldn't have had a probation officer?
No, he does, but he would have seen someone because he's not on us.
Oh, he's not on unsupervised. Got it. Okay, well, we'll sort that out. All right, good luck, Mr. Johnson. Stay with the program.
Yes, sir.
So I need to go sign something, and can we take like a 15-minute break? We have one plea left.
Well, it's actually gonna be just file here now.
Oh,
Oh, okay.
well, if we can do that in 2 minutes, we can do that now.
Yeah, I'll circle back with you. Yeah, perfect.
Okay, and then Mr. Davis, I'm gonna take care of signing your paperwork. Ryder Day is already here.
Stay right here.
This is Mr. Williams?
Yes, Judge.
So not a plea.
No, Judge.
Okay,
We're close though.
we're close. All right. All right. Let's get on the record. So we get all this down. 25 SC 000882, State versus Zachariah Williams. Mr. Williams, you are charged with terroristic threats. Ms. Wood, do you feel like you've got all the discovery in the case?
The only thing that I'm potentially missing, and I'm gonna get with Miss Davis, there's possibly a body camera that caught a terroristic threat. I don't have that, if it exists.
That said, caught it as in.
I don't know if they actually like saw a video that someone had and recorded it. There's mention of it in the police report, but we're gonna iron that out if it does exist.
Oh, I mean, so there's supposedly, this case is about a threat to a Yolanda Williams. Someone may have recorded that and then played it, and the officer said, play it in this box, and they recorded the recording. Understood. Okay. So we're looking into that, but you're comfortable having this moved to the trial calendar?
Absolutely.
Okay, great. Ms. Davis, if Mr. Williams wanted to enter a plea today, what is the state's recommendation?
Today, I was going to reduce it to a misdemeanor.
Okay.
And so the only primary condition was mental health plus treatment. The victim is his sister. And I did have a conversation with his sister about it. He doesn't have much of a history. And so that's the reason for the offer.
Got it. Okay. Mr. Williams, do you understand that if you entered a plea today, if you wanted to resolve your case today, that the state would reduce a felony, that's a serious case, down to a misdemeanor, less serious case, and the recommendation would be probation for some months and get an evaluation? That's what the state would be recommending.
Yeah, yeah, I want to hold off on that till a later date.
Okay. Fair enough. I just need to make sure you understand that. You may get that offer again, you may get a better offer, but I need you to understand that the state may change their mind and say, wait a minute, no, we're not going to reduce it. We'll still do probation, but they may say it's going to be a felony. You don't get to force them to keep the offer open. You understand?
Yes.
Okay, got it. Then we're going to move your case on to the August trial calendar. So just a couple months, 1 month from now, you'll be here. If before then you've worked it out, we'll see you before then, but otherwise I'll see you for the call of the trial calendar.
Okay.
Okay, I want to make sure we've got good info on you. I have an address of Rosewood Place in Fairburn. Is that where you live?
Yes, sir.
Okay, good. And you've got good contact for him, Ms. Wood?
I do, Judge.
And Mr. Williams, do you have a good phone number or email for Ms. Wood?
Yes, sir.
All right, then we're all set. I will see you in August.
Thank you, Judge.
Thank you all.
You're free to go. I'm gonna send you that excuse to your email.
So that's a wrap for today. I've got drug court in the morning, but then we've got jail Zoom in the afternoon. Another one of those productions.
So I didn't see in the system on my side that Mr. Phil Johnson has a whole community component. How do we do the program situation now he gets a whole?
We would want to round trip him to make sure he comes back here. So I might have to do a slightly longer sentence so that it's going to be tricky.
It did it through the jail instead of doing it through our system.
The warrant?
Yes, so, I'm positive it's for a revocation.
I was sort of wondering why that wasn't out there, but his probation is over in just a little bit.
Well, because it's first offender.
Oh.
We have that
Okay, yep. Let me think about that. I won't sign anything because it would be great, especially if we learn he won't be in Gwinnett long, to get him back here and get him transport. He is not gonna make it to Sonoya on his own. So we would need to do a transport order. So let's explore that one. I mean, everything else is the same. We won't change anything. I just might have to extend the custodial piece so that it covers Cobb, Gwinnett. Okay.
Judge, I just wanted to confirm that I can do a bench warrant for Mr. Hernandez, Avion Jeremiah.
Oh, right. We had someone who never,
Mhm.
That was the guy that was, that sat in Nick forever and ever.
Oh,
Yeah. Oh, you know what I can find?
yes, please. Bench warrant for number 9.
great. I did have another question, but I will save it for tomorrow, Judge.
Okay.
It involved asking the sheriff's office another question about jail sentencing.
Jail sentencing?
Yeah, so yesterday I asked about work release.
Oh,
Today I was gonna ask about home arrest. I found a statute about home arrest where somebody can be sentenced to house arrest, basically, house arrest instead of jail time.
Right. But I don't think that it impacts them. That would be where we give them an ankle monitor and they basically have a 24-hour curfew.
And they said something about the sheriff had to, I don't know, I'll,
Yeah, share the statute. Shoot me an email with the statute because I'm intrigued.
Yes.
That might be a good middle ground in some instances.
like, for the fleeing, that's really
Right.
where I'm at.
Oh, right.
There's no felonies, it's just,
Yeah. Yeah, that
That's so
statute
tough.
is, yeah. All right, Mr. Davis, let me go back there and take a look at that stuff.
The credit card, credit card, Mr.